Case diary is
Friday we
available.
are not listing cases, much more cases we are not listing. List numbers of
Yes.
cases have already been listed. 44.
Yes, ma'am.
What is it? It's a bail matter.
Yes.
What is the position bail matter?
On Friday.
Friday, no, not possible. Can you retain the case diary till next week?
Yes.
11, 12 or whatever. 11, 12. Are you on interim there?
No.
You are not on it. At a request made by Lana Council, however, it is submitted by Mr. Paul, CD receipt. Retain the case diary till next of listing, recording number 11th of May. City.
May please, Lord. Back to mention item number 20, my lord. Motion
20.
20, my lord. But the maintenance matter, I'm the wife, my lord. Some instruction, my lord, have thought for I'm calling her but not getting her phone. Can it be on Friday or Monday, my lord? Motion matter, my lord.
It's a motion matter. It is not possible.
On Monday, ma.
Monday. Okay, Monday.
Oh, obliged, my lord.
At a request made by Lana for the petition. There is action.
May I please, Your Lordship? Lordship, I beg to mention item number 40, my lord.
40.
In this case, as per interest, 40, my lord.
Yes.
CD not received, my lord. The petitioner is in
What is
interim.
the
bill.
position? What? Are you on interim?
Lordship.
Oh, CS submitted. Okay. What is the CS number?
CS number 67/26, dated 30/4/20.
So here we have received the case charge sheet already.
Then my
So
interim
we
need
are
to.
extending your interim.
Lordship, Lordship.
15 days will be okay?
Lordship.
15 days. We are extending your interim up to 15 days. Appear within 15 days. And
Lordship.
your interim will be extended.
Lordship.
CS number to load police. Okay.
Deeply obliged, my lord. Disposed of, my lord.
Yeah, it is this.
Lordship.
May I please, your lordship? Lordship, I beg to mention item number 36, lord.
36.
36, lord. Can it be on the next week, lordship?
Yes. What is the position of 36? Received. You are on custody, I think.
Yes.
12th of May.
Lord. Obliged, lord.
At the request in order for 12th May, CDBT delayed.
May it please, Your Lordship, my lords, I beg to mention item number 27. Due to some personal difficulty,
27.
my senior is not able to appear. May the matter be listed within 2 weeks.
Who is your senior? Mr. Ajay Das.
Yes, my lords.
Same order for you. Yes, Wednesday. After 2 weeks, anything. 2-1.
21,
21.
obliged.
Please, Lord. I beg to mention item number 18.
Yes.
Adjournment maybe even on Lord.
Item number 18.
18. Yes.
You are for the petitioner.
Lord.
At the request made by the petition. That should be accordingly listed. You want a fixed date here?
Lord.
You want any fixed date? Or after 2 weeks will do?
After 2 weeks.
Estimate accordingly after 2 weeks as on a date to be fixed. Okay, we are listing it after 2 weeks.
Hey, please, Your Lordship. I beg to mention item number 41. Kindly adjourn the matter for today and kindly fix the matter for tomorrow.
We have received this scan copy here.
Yes, Your Lordship.
That is fine. Maybe only. That will be on 12th. It will be
No.
listed on 12th, not tomorrow.
Your Lordship, can I kindly request you to fix it day after tomorrow if possible?
No, on 12th of May.
Okay.
This by best.
Item number 47, my lord. It's a bail cancellation matter. So notice was issued to the respondent, my lord. As
Yes.
check the records, my lord, notice has returned unserved. So we'll have to take fresh steps.
Why it is done?
Addressee was not traceable, the respondent.
You want to take fresh steps?
We'll take fresh steps, my lord.
Part Mr. S. Thomas, submitted that as a submitted that the notice issued to the respondent not to return answer. and hence paid to take precedent on it. In view of this, the petitioner is hereby directed to take precedent to respond to speed post and usual process. Let the matter be accordingly listed
After 3 weeks, madam.
after 3 weeks. Is it for cancellation?
Cancellation, madam. I'm deeply aware.
Item 22, Lordship. Sorry, adding the matter only few declarations. Matter may be taken after tomorrow.
22.
22, I will take after tomorrow.
You are for the petitioner?
A petitioner, I am for the petition.
Not day after tomorrow. Next week it will be. We are not taking tomorrow. Tomorrow day after, not forget about it. Huh? Yeah. It will be listed on 13/5 only. We are listing it on 13.
Lordships, I beg to mention item 37, my lord. Today is fixed for case diary, but case diary is not available. I heard from the other side.
Are you,
Interim order shall be continued.
you are on interim?
Yes, sir.
CD not received. It's a reminder. Yes, Port Harcourt.
My lord, 21,
21. So and so.
Din ho bola ni
Interim be
bahega.
continued till next day. We are continuing our interim till
Yes.
state of list.
Hello, Les.
May I please, your lordship? My lord, I was arrested on 8/3/2026 under section 108 of BNS, abatement to suicide. And I have been languishing in jail since then for more than 57 days. And the FIR was lodged on 8/3 on the date of my arrest. The fact of the case is, my lord, on 27/2/2026, my wife tried to commit suicide. And she called me via WhatsApp that she was committing so-and-so. And then I rushed to my home. I broke open the door and I tried to save her. And I took her immediately to Apollo Hospital. And she was being treated at Apollo Hospital. Then she was shifted to GMCH for further treatment. But on that day, she expired on 27/2/2026. In meantime, her sister, eldest sister, came and she lodged an FIR against me in under section 108. My lord, we have been married for more than 9 years. And there were no issue between us. And for twice we have been trying for IVF. I have enclosed the documents therein. She was suffering from mental distress. But whatever the allegation in the FIR is that I have been having some extramarital affairs with some other woman, and it has been alleged by the elder sister of the deceased. My lord, I preferred an bail application before the learned session judge, and it was rejected on by the order dated 8/4/2026. It is at page number 2426. Lordship may kindly come to Annexa 4, page number 24. That was the rejection order. My lord, on page number 4, page number 25, para 4, the learned session judge writes the perused case diary furnished by the IO. Perusal of the case record diary reflects that the IO has collected a postmortem report and sent the viscera to FSL for chemical examination to know the exact cause date. Case diary also reflects that the IO has recorded the statement of several witnesses, including the family members of the deceased and the accused. My lord, the statements of the accused has been, the statement of the witness has been taken, my lord. And the case diary, as well as from the statement, reflects the accused has been maintaining illicit relation with one woman, namely so-and-so, since several months prior to the incident, as a result of which the relationship between the deceased and the accused deteriorated. Case diary also reflected on 23/2/2026, the deceased found the accused with a woman in a photo at Gauhati in an inappropriate condition, which further deteriorated the mental strength of the victim, compelling her to take her own life. Case diary further reflects that the incident had occurred on the night of 27/2/2026, but the accused and his family members have not informed the same to the police. It appears that the accused person have been trying to evade police investigation regarding the cause of the death of the deceased. Case diary reflects that the report of disclosure has not yet been received by the IO and the investigation is on. My lord, by now, the investigation ought to have.
Yes, but
Otherwise, my lord, it seems that prima facie, my lord, section 1098 of the BNS is attracted. And finding materials, trial court also, my lord, rejected the bail petition of the petitioner, my lord. On that day, he, my lord, found her husband, my lord, in a compromising position. Thereafter, my lord, on that day, there are also allegations that before that earlier incident also, my lord, he beated the, my lord, deceased, my lord, as per the informant, my lord. And thereafter, on that day, after that incident, also there is materials that he instigated the victim to commit suicide. So considering these materials, my lord, my prayer before lordship, at least this CD may be called for.
from where it has to come?
Dispute police station.
Dispute police station. Dispute.
When we have
My lord,
next week, this week may not be possible.
yes,
Maybe on next week, any date.
12 of May, 12/5.
See.
I know.
But please also. Prohibition missing, Lord. What has happened in this case, my lord? The one Pranjal Bora, my lord, he purchased a vehicle from the informant, my lord, which was also, my lord, subject to hypothecation. Now, what had happened, my lord? 73,000 was to be paid by the accused, my lord, main accused. And, my lord, the EMIs of 42 EMIs were pending. That was to be paid by the accused. My lord, please, my lord, there was some shortage of money, my lord. I was requested. I have nothing to do with the affair as well as the agreement. An amount of 30,000 was sent online to the informant. That is the only connection. That was that the amount was paid by the petitioner. The lordship will kindly see the FIR at page 13. I am not named. No allegation against me in any way. My only grievance is that, my lord, I helped my friend to pay by paying an amount of 30,000. That is my only allegation. Mostly, I so and so would like to inform that I executed a written agreement for sale of vehicle being the same so and so with one Pranjal Bora, resident of so and so. In terms of the agreement, it was agreed that the accused would pay a cash amount of 73,000 and as advance, and then after clearing the 42 EMIs of which 12,365 each, I would transfer the vehicle in the name of the accused person. But the accused has taken the vehicle from 6 Mile, and till today the accused has not paid a single EMI against the loan. Since I was unable to contact him, and I have been compelled to inform you, therefore, so my lord, no allegation against. Now, lordship will kindly see the forwarding report, my lord,
At page.
at page 17, my lord. I'll just take you to the brief of the case. Complainant, lordship has got, my lord. Brief of the case, complainant Subhanga so and so, stating that the accused Bhaskar Soikia and Rishidas Bora. Bhaskar Soikia is the petitioner, my lord. Where from his name comes, other than the, my lord, transferring amount of online, my lord, at 30,000, there is no connection. I had that amount was loaned to my friend, and in fact, that amount is yet to be refunded. This is my case, my lord. From 3-4, my lord, I'm inside. And in fact, lordship will see the grounds of arrest in the same, the page 17, my lord. That as per the agreement, the accused was liable to pay. I'm not the accused in the case. That after taking possession of the vehicle, the accused failed to pay the agreed amount. That the accused has deliberately avoided contract and remained untraceable, indicating his intention to cheat the complainant and abscond from illegal obligations. That the act of the accused prima facie constitute offences of cheating and criminal breach of trust. My lord, no entrustment, no inducement, my lord. How can I be roped in, my lord, in this case? There are reasonable grounds to believe that the accused may tamper with the evidence, my lord. How? And since, my lord, 3-4, I was arrested on 3-4, my lord, 2 days police custody was given. I was interrogated in police custody, my lord, and thereafter I'm languishing in jail. Lordship will kindly consider, my lord, 32 days without any allegation against me.
What is the ground of arrest is cannot be done.
Yes, my lord, otherwise in the FIR only the allegation against Pranjal Bora. The difficulty is that my lord vehicle is not yet recovered, my lord. And regarding in the forwarding report only the name of Bhaskar Soikia and Rishiras Bora, alias Pranjal Bora comes only in the forwarding report. The accused Bhaskar Soikia and Pranjal Bora, my lord, mobile number took his car bearing registration, but in the FIR name of Bhaskar Soikia is not. Vehicle not yet
The
recovered.
agreement most probably this present petitioner was not in the agreement.
Considering length of detention only, but my lord, how he is involved, my lord, is
That
at
is
this
not,
point
that
of time
is not
difficult.
proven from the grounds of arrest also.
Yes,
It's not made out very clear that how he is connected.
Even otherwise, 2 days police custody was given, my lord. My statement has been recorded.
the vehicle was not recovered.
Vehicle recovered, means that is, there is an agreement to that effect. It's otherwise, vehicle can be traced very well, my lord. That is, I have nothing to do with it. Even if I'm in jail, my lord. How does it help, my lord? The main accused is outside.
Partition are they did not come. Mr. P. Water. Should be paid. It's application and submitted by Mr. T. Then no be connected to the eligible. Nor he is an independent. However, it is the fact that he helped his friend, the used to be the prime accused of this case, by transferring rupees 30 to his account and on the account, and that effort there is no involvement of this presentation. So after the arrest, he was also under police custody for 2 days, and since 32 days, the accused petitioner is in custody. Hence, considering his length of detention, and also considering the fact that the petitioner is no way involved in the arrest of this prayer may be considered. He will extend his cooperation to a further investigation. If it is next hearing, Mr. Water could learn that there is no specific mention about his involvement in the FIR. But from the recording report, it is seen that he is also involved in the arrest of this, and accordingly, he insisted for this. Next hearing is submission made by both sides, and considering all matters and the aspects of the case, this court will be opinion that further custody interrogation may not be required for the interest of investigation. And accordingly, I find it effective to transitions. Government with suspect to come. Okay,
Deeply obliged, my lord.
but it will be much.
May it please your lordship. Lordship, this is a regular bail application for petitioner before your lordship. Petitioner number 1 is arrested, lordship, and petitioner number 2, 3, 4 surrender. Petitioner arrested on 26/3 and the petitioner 234 surrender on 30/3/2026. Lordship, here FIR lordship will find on page 16, lordship. FIR lodged by the wife of accused, that is present petitioner number 3. Against this present petitioner lordship, that FIR lordship will find on page 16, lordship. May I read the FIR lordship? It is acceptably submitted that on 25/3/20 during the daytime at about 9 a.m. as per the instruction of the accused number 1 and 5, the accused number 2, 3, 4 assaulted me by hitting with bamboo stick, kicking and punching, thereby causing injury. The accused person forcibly handed a mobile phone to me and threatened me to call my father. Being helpless, I made the call, and after approximately 30 minutes, my father, Shahid Ali, arrived at her husband's house, and immediately the accused number 1 attacked Shahid Ali with knife, inflicting grievous injuries on his back. The accused person also assaulted my mother, Nasima Khatun, and accordingly, case was raised on 17-2 and 18-2, lordship. that is grievous hurt and grievous hurt with dangerous weapon, then criminal intimidation and common intention. Later, Lordship, this petitioner number 1 was arrested. Forwarding report, Lordship, will find on page 20, Lordship. Here only 1 day police custody was sought for, Lordship. Thereafter, Lordship, other petitioner, they are surrendered. That reflected on page 22, Lordship. Here what happened, Lordship, there is a cross FIR, Lordship. We lost the FIR, Lordship. That was not, although received, but it was not registered, Lordship. That FIR, Lordship, will find on page 29, Lordship. May I read that? It is respectfully submitted that the daughter of the accused person, namely Salma Khatun, is the daughter-in-law of the informant today, 25/3/26 morning at about 11 a.m. in connection with the domestic quarrel. The daughter-in-law called the accused number 1 over phone, and the accused number 1, accompanied with 4 other unknown persons and equipped with Dao X, and arrive at the house of the informant and illegally trespass into the house with and without any reason assaulted my husband, Mia Hussain. Along with the accused number 1, there are 4 other unknown persons with a view to kill my husband had attacked him with a sharp weapon. At that moment, my husband, to save himself, pushed the accused number 1 and tried to save himself, but those 4 persons who accompanied with the accused number 1 chased my husband, for which I could not get any information about my husband. Thereafter, I saw that the accused number 1 got injured due to the dao blow from one of the person who accompanied with the accused number 1. The daughter-in-law of the informant and the accused number 1 thereafter lodged false case alleging that the informant husband has caused Dow injuries to the accused number 1. They also threatened that we cannot come out from the jail. If come out, then they will cut my husband into pieces and will bury it inside the house, and I also abuse with filthy language, Lordship. Lordship, it's a family Lordship quarrel turning to Lordship balance, Lordship. Specific allegation against accused number 1 who attacked Lordship with a knife, Lordship, that is against petitioner number 1. Lordship. Other accused, Lordship, there is only no grievous injuries, Lordship, that was not alleged against this other petitioners, Lordship. Already, Lordship, 35 days and 39 days in jail custody, Lordship, considering the length of detention, Lordship. And one Lordship later, 109 was added, Lordship. Initially, it was not there, Lordship.
One zero nine.
109 added, my lord, page 25, my lord. Finding material against the accused person after recording the statement of witnesses under section 183 of the BNS assessment. Well, at this stage, my lord, CD may be called for.
Otherwise, Lordship, regarding other accused, Lordship, then only specific against the accused number 1, Lordship.
No, my lord, against other accused persons also, my lord. From page 25, my lord, 109.
Knife blow, that is by the accused number 1, Lordship. That is petitioner number 1.
Initially by Mia Hussain, my lord, petitioner number 2. Thereafter, all the accused persons.
Initially by Mia.
Mia
Initially
Hussain.
by Mia Hussain. Thereafter,
Thereafter, who caused injury?
from the FIR, my lord, reflects that those, my lord, statement of 183 of the BNS earlier, because 182 was there. In the FIR, only regarding accused number 1 is there. So only witnesses will reveal.
Accused number?
Accused number 1 is the, my lord, Ikramul Hussain.
He was arrested.
He was arrested in C.
Others were surrendered, Lordship.
183 statements will reveal, my lord.
Surrender order, that is on 22, Lordship.
CD, my lord, along with injury report.
He seems to be, Lordship, family dispute, Lordship. It's a husband-wife dispute. The father-in-law entered, Lordship. That's all hot altercation there. Such incident happened.
Your accused number one is Mia Hussain.
Accused number one is Ikramul Hussain.
Ikramul.
No, here accused petitioner is one.
Yes.
Ikramul.
good. Aye.
Petitioner number one.
Plus two is
Mia
as per FI, two is the Mia Hussain.
Mia Hussain.
He is the accused number one.
Yes.
It seems here from the FIR.
Mia Hussain.
Yes, ma'am. Mia Hussain is the accused
It's
number.
number one. Mia Hussain surrendered, Abdul Ali surrendered lordship. Only Ikramul Ali was arrested.
And 109 also added finding materials against Mia Hussain, that is specifically named. Regarding other persons, well, only 183 of the BNS will reveal how they are related. But all those persons in a group might not attack the victim. Regarding specifically specific materials against them, only statement of witnesses will be revealed.
Specific allegation against Mia Hussain, accused number one lordship.
Subject by Mr. George committed any such as the legend. However, it is a fact that there was quarrel and push and pull. Quarrel and scuffle took place. Quarrel and scuffle took place between two groups, and the accused person had also instituted and laws and FIRs. Laws and FIR, the same is not registered by the police. He further submitted that accused petitioner number one, Pramod Hussain, got arrested in connection with this case on 26/03/2026. Any other petitions, that is petition number 2 to 2, 3 and 4, 2, 3 and 4 that surrendered before police station on 30/03/2026, and since then they are in custody. However, during the investigation, section 109 is added on the request on the prayer made by the further submitted that there is no specific allegations against the other accused petitioners except the petitioner number 2, Mia Hussain, who stated that who allegedly attacked the one of the victim with a dick. But all these petitioners are debarred since last more than 1 month, and hence considering their length, they will be released. All the petitioners are ready and willing to accept their cooperation in further investigation of this case if they are granted with the privilege. Next, Mr. Watt, in an additional 50 days objection, submitted that their earlier bail application was rejected by the London Trial Court below, considering the materials in the case diary as well as the statement made by the victim of the cases. Mr. Waterford accordingly insisted to call for the case diary. However, he submitted that the specific allegation is brought against the accused petitioner number 2. Accused petitioner number 2, Mia Hussain, who attacked with a sharp object, causing grievous injuries on the victim. Mr. Waterford further submitted that considering the statement made by the witnesses under section 180 BNSS, section 109 is also added here in this case. Mr. Waterford accordingly insisted to call for the case. Next. Getting the submission with the counsel for both sides. I have also finished the case diary. I have also finished the case diary. The fact that as per the FIR, the specific allegation is brought against accused petitioner number 2, Mia Hussain, who also surrendered before the police station on 30/03. Considering all these aspects, this court is of opinion that the IO got sufficient opportunity to interrogate the previous petitioners, giving them interest. However, considering the fact that the accused petitioner number 2 had attacked the victim with a sharp object, for which section 109 is also added. This court is of opinion that city may be called for the accused petitioner number 2, Mia Hussain. However, the other accused petitioners are and for bail, considering their involvement in this case. Accordingly, accused petition number 1, 3, and 4, namely so and so, so and so, so and so, are hereby granted with the privilege of bail or rupees so and so to the satisfaction of CGM,
North Lakhimpur.
Lakhimpur, not. However, case diary be called for the accused petitioner number 2, Mia Hussain. Let the matter be accordingly listed on. Yes, not Gauhati, but no, so not
Not
Lakhimpur.
My lord, on 19th of May.
Can it be shorter, Lordship? 19 minutes is too long, Lordship. Already 39 days, 35 days in jail.
19th, my lord, on 15th of May.
Obvious.
Rest here we have granted.
I live.
Only in respect of petitioner number 2.
Yeah, please, Lord. This is an anticipatory bail application, my lord. There are two affairs, my lord. One is the counter affair, my lord, cross affair. My lord, kindly come to page number 16. This is the affair lost by the villagers against the poor accused person, my lord. Page 16, my lord. May I read, my lord?
Yes.
Here, my lord, accused number 1, 2, and 3, Abdul Motin, Mohidul Islam, Rajek Ali, Sottadikar of Lovely and Restaurant. Accused number 4, Malek Ali, he is the owner of a hotel, my lord, Royal Hotel and Restaurant. সন্মানপূৰ্বক বিনীত নিবেদন এই যে আমি তলত সহিকাৰী সকলে জনীয়া অঞ্চলৰ ৰাইজৰ হয় আপোনাক জনাব বিচাৰো যে আমাৰ অঞ্চলৰ অন্তৰ্গত লাভলি হোটেল আৰু ৰেষ্টুৰেণ্ট আৰু ৰয়েল হোটেল এণ্ড ৰেষ্টুৰেণ্ট নামৰ দুয়োটা ধাবাতে উপৰোক্ত আসামীগণে দীৰ্ঘদিন ধৰি একাংশ লোকৰ সহযোগত অসামাজিক আৰু অনৈতিক কাৰ্যকলাপ চলাই আছে। ধাবাটোৰ নিশাৰ ভাগত অবৈধ সুৰা আৰু নিচাজাতীয় সামগ্ৰীৰ মুকলি বেহা চলে। বাহিৰৰ পৰা অহা অচিনাকি লোকৰ আহ-যাহ বৃদ্ধি পাইছে, যাৰ ফলত স্থানীয় মহিলা আৰু কিশোৰীসকলৰ নিৰাপত্তা বিঘ্নিত হৈছে। নিশা হ'লেই ধাবাৰ ভিতৰত তীব্ৰ গতিত শব্দত গান বজনা আৰু গালি গালাজৰ ফলত পৰিৱেশ বিনষ্ট হৈছে। আমি স্থানীয় ৰাইজে ধাবাৰ মালিকক এই সন্দৰ্ভত কেইবাবাৰো সতৰ্ক কৰি দিছো যদিও কোনো সুফল পোৱা নাই। তথাপিতো আজি অনুমানিক দিনৰ 1মান বজাত উপৰোক্ত আসামীগণে বাহিৰৰ পৰা ছোৱালী আনি দুইটা ধাবাতে অনৈতিক কাম কৰাৰ বাবে সচেতন ৰাইজে হাতে লোটে ধৰি বৰপেটা প্ৰশাসনক সমজাই দিয়ে। এনে পৰিৱেশ আমাৰ সমাজৰ নতুন প্ৰজন্মৰ ওপৰত বিৰূপ প্ৰভাৱ পেলাইছে। মানে this affair is lost by the villagers against these accused persons. Now, my lord, this affair is lost on 12/1/2026, my lord. And this affair is registered as Borpeta PS case number 20 of 2026. Now, the accused number 4, Malek Ali, he has lost a counter FIR against this, my lord, the informant and villagers. My lord, kindly come to page number 26, my lord.
Yes.
This is a cross affair, my lord, lost by the accused number 4 in Borpeta PS case number 20, and here he is an informant, my lord. Asami Azad Hussain, Abdur Rahman, this petition is for Abdur Rahman, my lord, accused number 2. Imran Khan, Joel Khan, Nurul Islam, Ariful Hussain, Rafiul Awal, and others. Now, my lord, except the accused number 2 in the present FIR, all are the informants in the earlier FIR. my lord. Now, the allegation is, my lord, in the present FIR, এজাহাৰকাৰী বিনীত নিবেদন এই যে মই জনিয়া বৰপেটা ৰোডত কাষত ৰয়েল গেলেক্সি হোটেল নামৰ এখন হোটেল চলাই আছো। আছামীগণৰ লগত আগৰ পৰাই আমাৰ লগত শত্ৰুতা চলি আছে। মোৰ অনুপস্থিতিত আছামীগণে একেলগে দলবদ্ধভাৱে হাতত মাৰাত্মক অস্ত্ৰ লৈ মোৰ হোটেলত অনাধিকাৰী প্ৰৱেশ কৰি 12/1/2016 তাৰিখে দিনৰ প্ৰায় 12:30 মান বজাত 1 নং আছামী নেতৃত্বত বাকী আছামীগণৰ সহযোগত মোৰ হোটেলত প্ৰৱেশ কৰি মোৰ দোকানত থকা সকলো আচবাব এচি ভাঙি লুটপাট কৰি আছামীগণে লৈ যায়। তাতে প্ৰায় 10 লাখ টকাৰ ক্ষয় ক্ষতি কৰে। মোৰ দোকানৰ কৰ্মচাৰী উছমান আলী, জানি আলম, শুকুৰ আলী আছামীগণক বাধা দিয়াত সিহঁতক মাৰপিট কৰে। বৰপেটা থানাত ফোনযোগে জনোৱাত থানাৰ পৰা পুলিচ গৈ পৰিস্থিতি নিয়ন্ত্ৰণ কৰে। বৰ্তমান আছামীগণে মোক নানা ধৰণৰ ভাবুকি দি আছে। Now, my lord, this affair is a cross affair, my lord, with the intention of ulterior motive, my lord, to neutralize the earlier affair, my lord. Now, the role of the present petitioner and accused number 2, my lord, he was not the informant in the earlier affair. My lord, kindly come to page number 30. My lord, the incident took place on 12/1/2026, my lord. And my lord, kindly come to page number 30. It is an agreement, my lord, executed on 8/1/2026 between the informant, my lord, and the present accused petitioner, my lord. The hotel was, my lord, previously owned by the present petitioner, my lord. And he has sold out the said hotel, my lord, to the informant on 8/1/2026, my lord. Page 31, my lord. This sale agreement is made on 8 January 2026, my lord. Here, my lord, point number 4, that the first party has paid an amount of rupees 9,66,000 only to the second party. The second party is the seller of the hotel, has already given first possession upon the hotel to the first party. So, my lord, since 8/1/2026, my lord, the present petitioner has no manner right, title, and interest over the said hotel, my lord. So, this FIR lodged by the accused number 4 in the earlier FIR, my lord, as an informant, my lord, with a motive to neutralize the earlier complaint, my lord. So, my submission before your lordship, my lord, as this FIR has been registered under the non-bailable offences, my lord. So, the petitioner moved this bail application before your lordship with a document, my lord, that the present petitioner, he was earlier the owner of the said hotel, and he has executed an sale agreement with the informant, my lord, on 8/1/2026, my lord, and he has handed over the possession of the said hotel. So, the present petitioner is nowhere related with the incident of 12/1/2026. Even the 12/1/2026, the villagers have lodged an FIR against the owner of the said restaurant, my lord. And one of the accused in the said owner of the said hotel, my lord, he has lost and counter FIR, my lord, including the name of the present petitioner, my lord. And other petitioners are, my lord, the informant in the said FIR, my lord. They are the villagers. So, my submission before your lordship, my lord, and protection may be given to the present petitioner. He will appear before the investigating officer, my lord, will record his statement. Also produce this document, my lord, before the investigating officer, my lord.
These, the accused persons are all are the informant of the other case,
My lord,
earlier case.
earlier case, my lord. I have annexed all the names, my lord, in the FIR, my lord. It starts from page number 18, my lord. Except the petitioner, accused number 2, my lord, all others the villagers, my lord. They are the informant in the earlier case, my lord. Only to neutralize the earlier complaint, my lord, the accused number 4 as an informant has lost this cross FIR, my lord.
Otherwise, my lord, from the present FIR, it's reveals the informant is the owner of that hotel, Abdul Malik. And the present accused is the Abdul Rahman, my lord. And before that, my lord, earlier, yes, some illegal activities is going on. For that, my lord, one FIR has been lost by the, my lord, accused person regarding that aspect of it. But from this agreement, my lord, it reveals that one agreement is there between Abdul Rahman and, my lord, the informant, my lord, informant and the accused, my lord, Abdul Rahman, present petitioner, and between accused and informant, my lord. So he wants to, so illegal activity is going on that hotel, my lord, that is true. But regarding the why, regarding this agreement that, my lord, Abdul Rahman with the owner of the informant, my owner of the hotel, my lord, that is informant, my lord, all these things, something is going on, my lord. Already they tried to, my lord, shift the burden to anyway, my lord. Probably he has purchased without taking possession. Something is there, my lord. Only CD will reveal. Otherwise, as prima facie, it seems that, my lord, earlier also, my lord, against that hotel owner, the present petitioner has lost the affair that something illegal activities is going on. But it is also fact from the agreement that, my lord, my lord, there is some agreement between the parties for
Yes.
it. Let me record his
The
statement.
informant of this case is also, is not the accused of the other case.
My lord,
Informant of this case, Abdul Malik, he is not
he's the accused in other case, my lord. Accused number
Accused.
4.
His name is shown as Malek Ali, probably Malik.
Malek Ali.
But here Abdul Malik, whether Malek Ali or Abdul Malik is the same person.
Same, my lord, because from the statement in the second affair, my lord, it is stated that I am the owner. Anyways, my lord, I will record my statement, my lord. I will produce the document of the agreement, my lord, before the investigating officer, my lord.
No, only because that some illegal activity is going on in both the hotels, probably to get rid of that. Well, probably because he is also one of the, my lord, my lord, that agreement is also there between the present petitioner and the hotel owner, my lord. Something is there
This
that
agreement is for which hotel?
that agreement is for, my lord, selling the, for
That-
purchasing that, that
Galaxy Hotel, my lord.
Galaxy
No,
Hotel.
this is Galaxy.
My lord.
There are two hotels in the, that in the
Yes.
FIR lost by the present petitioner to Sattadhikari Lovely Hotel or Restaurant and Sattadhikari Royal Hotel or Restaurant. So some illegal activities is going on in both the hotels. And the present petitioner is trying to purchase one of the hotel with from the, my lord, owner of sale Royal Hotel and Restaurant.
No, not present petition, but the informant.
Informant.
No, present petitioner also Abdul Rahman. He is the present petitioner. Agreement
No, he was the owner.
seller, my lord.
Yes, seller.
Seller. So initially he was the, my lord, owner of that hotel, Abdul Rahman, present petitioner. So something illegal activities is going on. So shift the burden, my lord, everything is going on.
So detail will be done also petition. But should be what will be done in petition if we agree on behalf of state. It's an application. It is submitted by Mr. Ahmed and further figures. There is no way connected in the list. It's the fact that some of the villagers had earlier instituted case against the owner of, against the present informant and some others with the allegation that the hotels which they own are the allegation that some illegal activities are going on in the hotels. Two hotels, namely one Lovely and one Royal Galaxy. That's only to neutralize the earlier FIR. The present FIR has been launched by the owner of the hotel, this Abdul Malik, against 8 numbers of petitions, out of which 7 numbers of the petitioner, accused persons were the informant of the earlier case. However, the present petitioner Abdul Rahman was not the informant in the earlier case, but he was the owner of one of the hotel Galaxy, which was purchased by the present informant after an execution of after entering into an agreement settlement. But the present petitioner, but the informant had lost it with the FIR with some false and concocted allegation as the informant as one FIR is earlier lost by the villagers with the allegations of involvement of the owners in involvement of the owners in some illegal activities. However, the present petition is ready and willing to cooperation in further investigation of this case if it is granted with some interim provision. Next. Hearing Mr. Porter submitted in the state. That as per the allegation, there was some illegal activities were going on in the hotels. But as per the present allegation, but as per the present FIR, the allegation is brought against the accused persons. That on the day of incident, they entered into the hotel and entered into the hotel and entered the hotel and vandalized the entire by the accused persons. Mr. Gordon submitted the city may be called to know the effects. Next, by hearing the submission made by landlords for both sides. In other aspects of this, this court is of that one opportunity may be given the present petition for present petitioner so that he can and cooperate in the investigation. In view of this, in interim protection. Okay, will be provided with some interim protection.
My lord.
Yes, whatever when it can be.
My lord, on 26th of May, 26th.
Listing out on 26th of May, abide by all terms and conditions, we are in.
Highly appreciated.
May I please, Lordship?
Yes.
My lord, this is 3 years bail application, my lord. Allegation is under section 329(4), 308, 1152 to 96, 351. My lord, only 308 is the non-bailable section.
Pardon?
My lord, only section 308 is the non-bailable section extortion. But my lord, surprisingly, there is no any delivery of property, my lord. Now I am coming to the FIR, my lord. FIR is at page number 11, my lord. May I read, my lord?
Yes.
The humble submission is that one Motleb deposited ₹12 lakhs in our Jubashakti Sanchayaru Rindan Samabhai Samiti Limited. In this regard, on 17/4/2026 at afternoon, called and asked me to give ₹24 lakhs and also asked to me give my land and house in his name. But while I did not do so, then he assaulted and revoked me. Somehow I saved my life and returned back home. Again on the same night at about 12 a.m., Motleb and his 2 sons, along with Bapukan, came and entered into my campus by breaking the gate and knocked my door and tried to break down the door, but they could not able to break the same. They threatened to murder me by shooting and stabbing. Finally, finding no alternative, I dialed in 100 and later on the police arrested them. My lord, now FIR lodged by us, my lord. Page number 19. The humble submission is that I have an account in Jubashakti Private Society Limited, situated at Hatigao, Sijubari. The account number is such and such. In the said account, I have deposited an amount of ₹12 lakh. Basir Ali and Zahir Ali are the owner of that society. Though since from February, I severally went to the office to withdraw the deposited amount, but they gave various days to collect the money. Yesterday at about 10 p.m., Basir Ali called my husband, namely Motleb Ali, to Moidul Islam at his home to return the deposited money. As such, my husband went there, and after his arrival, Basir Ali and his family members misbehaved him and threatened to murder him. Furthermore, he threatened to suffer dire consequences if he comes again for the aforesaid. So, my lord, by this time, CD may be called on and we may be protected, my lord.
Your
There
lordship,
is no delivery of property at all.
your lordship may kindly take up this matter along with item number 8. Item number 8 is the cause one other affair against the same incident, my lord. Not same incident, my lord. Hatigao PS 72, my lord.
Is a cross FIR case.
Yes,
Divide, Item number 8. Question and then more.
We call for.
Yes, it is there. Your lordship may also, in this case also, your lordship may kindly peruse the that affair at page 19, ma'am.
Yes, page 90.
Page 19.
Yeah, huh?
Here the present FIR is at page 11.
Yes, yes. 80. No, it to tomorrow. In the present case, your lordship may kindly see the briefing.
এই মধ্যে বই তুমি কার কানে পাইলে মই এইটো জাহিদুল ইসলাম মই মতলব করতে ছাত্রদের উপর থাকা মানে তো কিনা মতলবের ওয়াইফে রাসকালি জাহিদুল গোলাম আলাইকুম তোমার মানে তুমি জাহিদুল কেন মই মতলব
The FIR page 19 is lodged by wife of Motleb.
মতলব
Only case diary will reveal the actual fact, ma'am. Otherwise,
But 24 lakhs is not deposited or was not taken.
yes, yes.
70
Otherwise, my lord, in say,
Demand was made at.
yes.
my lord more than 7 crore rupees is appropriated by the informant in the instant case, my lord. More than 7 crore rupees. So, my lord, we may be given interim protection, my lord.
In both cases, my lord, CD may be called for at least.
My lord. CD may be called for by this time, my lord. We may be protected.
To find out the actual.
The by the wife of you for how many petitioners here?
4 petitioners, my lord. In item number 5, 4 petitioners.
One is not the FINMD.
My lord, one is the affair name, my lord, Motleb.
No. Yeah, in the FIR only 3 names are there.
My lord.
Motleb, Papukon. The 2 sons.
2 sons, Sajid Akhtar and Shahbaz.
Wife of accused number, accused petition, which is also accordingly lost under taking of PS had taken of PS case number 72 of Sir Paramani accordingly submitted that some protection may be provided as a petition so that that can appear before the IO and can bring the actual facts. So, proceeding may be called investigated without passing any order. During discussion made by witness. Yes. Yes. Support. So that they can appear cooperate according. Yes, Botakur, when it can be called for, they will be under interim protection.
Yes, my lord. On 20, my lord, 21st of May.
21st of May.
May.
Highly applied.
I am for the item number 8, man.
Yes.
Regarding item number 8, my lord, already there is, my lord, only the mention amount is rupees 12 lakh regarding the present, my lord, informant. Although during argument, my lord, regarding how much amount only, regarding if any other persons, my lord.
Dear my
only
lord,
CD will reveal, my lord.
my lord, dear my lord, petitioners are not the FIR name Akush, my lord. They are the daughter and son of my lord, Akush number 1, Basir Ali, my lord. The petitioners are not the FIR name Akush, my lord. They were no way connected with
They
the.
were operating these things. Huh?
No, no, my lord. They are no way connected with the LS.
No. He's their father, Basir Ali.
Yes, my lord. He's the Akush number 1, my lord. He's the father of the petitioners, my lord.
Here allegation is only that the family members insulted and threatened.
That is the allegation. That is admitted fact, my
those
lord.
the amount, but regarding those
Rest the allegations are against their father.
Father, my lord. Father, Basir Ali.
regarding misappropriation, my lord,
Yes.
all those allegations are not there. CD will
You are Mr. J. Ali.
Yes, my lord.
And this is the, my lord, prima facie from the FIR. It seems that, my lord, they are involved in, my lord, collecting money by way of those deposits. Maybe the in FIR, my lord, everything is not there. Probably
Seems to
during
be, yes.
investigation, many things
The
may
name
come.
of that.
So, my lord, CD may be at this stage, my lord, call for, my lord, my prayer because of it.
My
May
lord.
not be, my lord, those allegations are not there, but how they, my lord, collected such a huge amount, under what, my lord, authority they have collected these amounts. Although regarding those allegations are not there, but from the prima facie, from the contents of the FIR, it seems that, my lord, something more comes out during investigation.
That is admitted, my lord. That is against the father of the petitioners, man.
Mr. J. Ali done. Report. Giving it interim protection. You'll be under interim protection.
Mine.
On
okay.
Same day.
21/5, my lord.
My please, your lordship. My lord, before going into the FIR, your lordship, I beg to draw lordship attention at page 22 to 26, your lordship. It is the cross FIR because for the first time we did file the FIR, your lordship. So as a counter blast, they have filed the FIR against us, your lordship. That is page 12 to 21, and our FIR is page 22 to 26, your lordship. Here in this case, your lordship, what happened is that is lordship the informant took an amount of rupees 1,50,000, your lordship, in the name of providing PSP of SBI, your lordship. So accordingly, that amount was paid, your lordship. So time elapsed, a long time elapsed, but the assurance has not been fulfilled, and therefore insisted time and again, your lordship. So then, your lordship, they assaulted us, denied to return back the money, and as well as, your lordship, all the accused persons, they have inflicted us blow and fist and kicks and all, your lordship. They are also in the hospital, your lordship. I have annexed this certificate also, lordship. Kindly, first of all, page 33, your lordship. Page 33, two installment they have taken the money. Page 33, first time 73,000 was taken, Your Lordship. That is an online payment. And thereafter, Your Lordship, last payment is, Your Lordship, that is 1,50,000 is, that is page 40, Your Lordship. Musharraf Hussain and Amdadul Islam, Your Lordship, 1,50,000 taken in the name of CSP. So there is an agreement. Both parties signed, Your Lordship. So out of this, due to this transaction, Your Lordship, some altercation had taken place because we insisted when the time rolled by, they did not, neither they provide the CSP nor return back the money. So some interrogation had took place, Your Lordship. And as a result of this, they all, Your Lordship, assaulted us, Your Lordship. Page 34 may kindly be looked into, Your Lordship. This is the discharge certificate. So one of the, Your Lordship, our petitioner was admitted in the hospital on 18/4/2016, 26, Your Lordship, and then discharged on 20/4/2026, Your Lordship. So when we filed the, we lost the FIR, Your Lordship, no action taken, Your Lordship. Thereafter, again, we lost another FIR before the Superintendent of Police. That is also there, Your Lordship, page 27 to 32. Now, Your Lordship, I am coming to the FIR lost by them, Your Lordship. That is at page 12. Here in this case, allegation is that the accused number two collected 6 lakhs of rupees from the informant concerned and as well as some other women in the name of, Your Lordship, investing money in the share market by making false promise, representation, and thereafter misappropriate the said amount, Your Lordship. On 17/4/2026 at around 9 p.m., 9 a.m., I inquired about the money, and the accused number two, he uttered some filthy language. On hearing the commotion, other accused person arrived at the place of occurrence. Thereafter, the accused number two bite my left hand. And the accused number three caught hold of my tuft of hair and dragged me on the floor. When my husband, namely Amdadul, came forward to intervene, the accused number one inflicted blow on his body, as a result of which his head was fractured. Thereafter, the accused number 2, 3, and 4, with the intention to kill my husband, assaulted him with fists and kicks while he was unconscious. The accused number 6 gagged his throat, and the accused number 5 again caught hold my tuft of hair and assaulted me with fist and kicks. I am not for accused number 6, Your Lordship. It's a different person. While the neighboring people intervened, we were saved, and thereafter my husband was immediately taken to the Moirabari hospital. Considering the gravity of the injuries, he was referred to the Nagaon hospital. This is the allegation, Your Lordship. And allegation mainly confined to, Your Lordship, the accused number 1. So here is the one fatal allegation is that inflicted blow on his head, Your Lordship. And they brought the allegation that due to the fatal blow, Your Lordship, on head, so head was fractured. So accordingly, she was actual fact is that, Your Lordship, some because the chest, the accused person in the counter affair we have filed, Your Lordship, the accused person chased us, and by breaking open the, Your Lordship, the gate, they entered into our premises. So as a right of private defense, Your Lordship, some, Your Lordship, incident had occurred, Your Lordship, and both sides injured, Your Lordship. It's not that they have taken money from us, Your Lordship, with some false promise. And this is the, it is on the face of the, Your Lordship, the agreement itself, Your Lordship, that 1,50,000 taken, and online on 73,000 was taken. This is apparent on the face of the record, Your Lordship. So my humble prayer, submission before Your Lordship, that so far the allegation against other persons are concerned, Your Lordship, then the accused number 2, Your Lordship, bite left hand. Accused number 3 caught hold of hair, Your Lordship. And accused number 4, against him allegation is the fist and kicks. And again, the accused number 5, these are all two ladies, Your Lordship, Mushida Begum and Mumtaz Begum. They caught hold the tuft of hair of the, Your Lordship, the informant, and Your Lordship, this pulled on the ground, Your Lordship. So this is the allegation. Main allegation is against the accused number 1, but Your Lordship, is a simple injury so far the information derived, Your Lordship. We have got the grievous injury, Your Lordship, and therefore, Your Lordship, we are there in the hospital undergoing treatment for 4 days in the hospital, Your Lordship. Still, Your Lordship, it's not safe. Unstable condition of the, Your Lordship, one of the petitioner is unstable, Your Lordship. So my humble prayer, Your Lordship, is that it's a fit case to invoke the privilege of free arrest bail, Your Lordship. At best, Your Lordship, we may be allowed to appear before the police station, Your Lordship. Later statement be recorded by the police, Your Lordship. In the meantime, the CD may call for it.
Yes.
My lord, firstly, my lord, accused number 2 is the petitioner my lord, is the petitioner number 2 in the petition, my lord. Musharraf Ali.
Petitioner number 2.
Yes, yes.
Accused number 2 is the petitioner number 2. And my lord, regarding first allegation is that he collected an amount of rupees 6 lakh. There false representation is also there. Thereafter, my lord, on the pretext of investing that amount, all those he misappropriated those amount of rupees 6 lakh. That is first allegation against accused number 2, Musharraf. Here also petitioner number 2. And regarding the other petitioners, my lord, accused number again Musharraf, my lord, that he bite my left hand. And number 3, that is specific allegation against regarding injury part, my lord, regarding misappropriation of rupees 6 lakh first. Next, my lord, bite my left hand, second allegation.
That I have already submitted.
And third, my lord, against accused number 1, my lord, that is Sekbor Ali, inflicted on his body as a result of which his head was fractured. So, my lord, specific allegation against accused number 1 and 2, they are also petitioner as 1 and 2. And regarding other accusation, my lord, thereafter the accused number 2 and 3 and 4 with intention to kill my him uncondemned. And my lord, treatment is still going on, considering the gravity of those, my lord. So at this stage, my lord, regarding allegation of misappropriation of huge amount of money on the pretext of, my lord, investing that amount in, my lord, share market, and thereafter this injury part, all allegations are there against accused number, specific against accused number 1 and 2. Against 3 and 4 is also there, but my lord, mainly 1 and 2. My lord.
Lordship, these are totally accountable as to Lordship.
Not only, my lord, they assaulted,
counterfeit.
but also misappropriated huge amount on the pretext of investing.
Kindly see the page 42, Lordship. That is the agreement you Lordship entered into between the parties, Musharraf and you Lordship, Emdadul. That is the husband of the informant, you Lordship. So they entered into that agreement, taken money 1,50,000 Lordship.
This is don't repeat. You have repeated 4-5 times.
This 40.
And so it- Further submitted this is the process. This is the process when the wife of who lost your process?
Lordship, prosecutive Lordship, post 22, Lordship. Lordship, wife of the accused number 1 in my petition.
The one. We did the copy. One week. One. Two catch.
Musharraf.
Which were taken within the name of the CSP independent. When they returned the money, assaulted the and with false allegation, right? However, he submitted that there is election against two and 1 and 2. 1 and 2, but there is specific election. Yes. Accused number 4 and accused number 3 and by the woman who falsely implicated all the accusation and within important it's support that there is election of misconduct and that apart the election assaulted against him. However, he submitted that there is specific election of misappropriation assault by accused number 1 and 2. And other accused petitioners are will also seems to be involved in the act. Accordingly, Mr. Bottom insisted to call for case during the submission in and other scored of opinion and accused petition 4 and 5. disseminate. However, interim prayer practice number 1 and 2 is not considered as such. 3, 4, and 5 will be some interim protection. 1 and 3 is what happened when it can.
Well, FIR is lost by Musharraf, madam, not his wife, madam. As
No,
petitioner.
no, Lordship, that is space 27 by Musharraf also, 2 FIR. This is before the additional superintendent of police. It is the second one, Your Lordship.
When it can be called.
On my lord, 26th of May. madam.
3, 4, and 5, Your Lordship. Demobilize.
May it please your lordship.
Yes. Yes.
Your lordship. Lordship, this application is filed on anticipation of arrest by the Parliament PS case, lordship. Your lordship, petitioner 1 is the son and petitioner 2 is the mother of 76 years old. And the incident cropped up from a consensual relationship with the petitioner 1 and the informant, who is a very influential journalist, lordship. And she has initiated with the filing of a case against the petitioner in Olaman PS, lordship. Olaman PS is constantly chasing the petitioner, but not disclosing the FIR, lordship. That led to the petitioner to approach before this honorable court. So may I pray, lordship, at this stage, a report may be called for. At the same time, may I pray that against petitioner 2, he is a 76 years old lady, lordship, that no coercive action be taken. That observation. That is my prayer.
GD entry.
ZD
GD entry
is
number you
section.
could not collect.
Section has been disclosed, but FIR number is not given.
FIR no, GD number.
GD number, it's not disclosed, lordship.
While FIR section 64, 69,
Yes.
351,
That
2,
has
3184,
been disclosed. That
303,
that
everything is there. So, my lord, I will have to get the instruction, my lord.
Not.
Well, at this stage, any sort that
So
will be
GD entry is there.
picked.
I mean, GD
It's
entry
nil,
number is near. How it can be?
Yes, well, your
When
lord
the
may kindly.
other sections are there.
Yes.
Yes.
Well, at
Can you
this
check
stage,
it out day after tomorrow then?
day after tomorrow, without any interim.
The interim we are not providing it
Lodge.
after tomorrow.
Lordship.
Hard. Must soon be done. In which police station you are suspect?
Olaman PS case, lordship.
All
Olaman.
No connection. That the present accused petitioners are being searched by the police from Olaman police station. And station on the basis of a GD entry, which has not been disclosed. The number which has not been disclosed to is it is registered under section 64, 69, 71, 351 to 352, 3184, 303, and other related sections. In view of this, detailed report we call for from Olaman police station as to whether any case has been instituted against the present two petitions in Olaman. The additional people will call for the report from the concerned police station. Yes, day after tomorrow. 6th.
Lordship, will the lordship
No.
for petitioner
No,
2,
we are
lordship,
just-
may I
We
pray?
want to see it.
Oh,
And that day you can
Lodge.
be
Lodge. And deeply.
May it please the Lord. Anticipatory bail application, offences of cheating and criminal breach of trust, madam. The Lordship will find the FIR at page 15. May I read the FIR, madam?
Yes.
Dear sir, with due respect, I would like to bring to your notice a case of cheating and fraud committed against a customer involving deliberate deception, misuse of trust, and wrongful loss of money. During the course of verification, it has been revealed that Shri Mufidul Hussain, erstwhile BM, branch manager, who who was then posted at Piplibari branch and entrusted with duties relating to appraisal, sanction, disbursement, and monitoring of loan accounts, deliberately violated banking norms and sanction stipulations. The accused facilitated sanction and/or disbursement of loans without ensuring compliance with mandatory conditions, suppressed material facts, and failed to enforce closure of existing loans despite explicit stipulations, thereby abusing his official position and trust reposed in him by the bank. Mufidul Hussain is not before this honorable court, my lord. Piplibari branch was functioning as a single-man branch where Shri Mufidul Hussain processed and recommended loan proposals to RACC Gauhati Rural. The loans carried a stipulation that existing loans were to be liquidated out of new loan proceeds. However, this was not complied with. Borrowers were induced to issue blank checks and withdrawal slips on the pretext of loan closure, but the amounts were not credited to the respective loan accounts and were fraudulently withdrawn. Shri Parag Mani Das, now Parag Mani Das is the petitioner, my lord, who is not a bank employee, misrepresented himself as a bank functionary, collected checks and withdrawal slips from borrowers and facilitated fraudulent withdrawals and diversion of funds, convincing the customers that the previous loan will be closed. It was further found that EMIs were paid irregularly through cash and UPI via suspected middlemen. Such payments and portions of disbursed loan amounts were traced to the account of Shri Parag Mani Das, establishing a common modus operandi and money trail. Specific accounts involved are as follows. So these are the 5 accounts, my lord. Next, please, my lord. Subsequently, the victim came to know that the amount withdrawn by him was neither deposited nor adjusted for the stated purposes, and the said amount had been wrongfully misappropriated. It is evident that Mufidul Hussain, the then branch manager, in connivance with Parag Mani Das, who is an outsider, working as a middleman, played an active role in enabling, facilitating, and allowing the above acts of cheating and fraud, thereby causing financial loss to the victim. As per the FIR, it has been projected that Parag Mani Das, I am a middleman, I am an outsider, I am not a bank employee. Now, your lordship will kindly come to the next page, my lord, page 17. Now, this is a letter issued by the State Bank of India, that very bank, my lord. Your lordship will see. With reference to the caption subject, we hereby allot MS Agile Ayush Associates, legal representative Shri Parag Mani Das, to do recovery in NPA and AUCA accounts pertaining to your branch. And all other documents, my lord, given. So this person, my lord, he was not an outsider. This person was working as a recovery agent for the SBI. He was working there as a recovery agent, and this aspect which has been revealed in the FIR, that these EMIs which were paid, some of it were paid through cash and UPI, were suspected, were traced to the account of Parag Mani Das. So this part is again not being disputed. Parag Mani Das has been working as a recovery agent in that bank for the last 15 years, my lord. And in many of the cases, my lord, these EMIs were paid to UPI in his account, and which was again given to the bank, my lord. So the paper money trail is always going to be there, because the money in many of the accounts was routed through Parag Mani Das and was paid to the account of the SBI. Now, other aspects, my lord, what is his exact role? Because primary allegation is against Mufidul Hussain, the bank manager. That the case diary will reveal, my lord. Now, the only submission with your lordship is the offences which has been, which are there in these cases are punishable with imprisonment up to 7 years. So in these cases, my lord, as long as the accused is willing to appear and cooperate with the investigation, my lord, perhaps custodial interrogation may not be necessary, because this person.
Have you received any notice now?
I have not received any notice, but they have called me to the police station, and on the last working day, on Saturday, I went to the police station, and thereafter, my lord, they have again asked me to come on the next week, my lord. So I have appeared once, my lord. On the face of it, the allegations are there, my lord, but considering that offences are punishable up to 7 years, if I am willing to appear and cooperate, perhaps, my lord, arrest may not be necessary, my lord. At the end of the day, everything will be document-based, my lord.
Your lordship, my lord, yes, my lord, from the appointment letter of the branch manager, State Bank of India, he is a recovery agent of the SPM. And from the allegation, by taking advantage of a recovery agent, how he, my lord, involved, my lord, cheated the borrowers of the loan, my lord. What happened? Borrowers who are already having existing loan in their bank account. In the next time, my lord, that now the present loan has been, my lord, granted to the borrowers on the pretext that your earlier loan will be adjusted in the new loan. Now, what these accused person have done without adjusting those loan measures, after taking my lord checks and my lord deposit slips, my lord, they withdrawn those amount and misappropriate those amounts. Later on, those customers, my lord Loni came to know that those amounts in fact were not adjusted in their new account. So how they are involved in my lord cheating, my lord, in fact, my lord fraudulently misappropriated the amount of the customers. Along with the bank manager, my lord Mofidul Hussain, he is directly, and the present petitioners also, there are specific allegations, my lord. Your lordship, I would like to again point out already, although he has pointed out, my lord. The loans carried a stipulation that existing loans were to be liquidated out of new loan proceeds. However, this was not complied with. Borrowers were induced to issue bank checks and withdrawal slips on the pretext of loan closure. But the amounts were not credited to the respective loan accounts and were fraudulently withdrawn. Sri Paragmani Das, who is not a bank employee, admittedly he is not a bank employee, he was appointed as my lord recovery agent by the SBI, misrepresented himself as a bank functionary, collected checks and withdrawal slip from borrowers and facilitated fraudulent withdrawals and diversion of funds, convincing the customers that the previous loan will be closed. It is further found that EMIs were paid irregularly through PAYS, those are UPI via suspected middlemen. Such payments and portion of disbursed loan amounts were traced to the account Sri Paragmani Das, establishing, so those accounts in fact reflected in the account of Paragmani Das, those EMI were paid, establishing a common modus operandi and money trail. Consequently, the victim came to know that amount withdrawn by him was neither deposited nor adjusted for the stated purpose, and that the said amount had been wrongfully misappropriated. So, taking advantage that he is a recovery agent of the bank, without intimating the customers in that manner, he in fact projected himself as an employee of the bank. Thereafter, my lord, in fact, he along with the bank manager supposed to close the earlier loan, but in fact,
That was not done.
without closing that, my lord, they misappropriated the customers' money, my lord.
Whether, my lord, now the only thing, my lord, whether they will require my custodial interrogation. That is the only aspect, my lord. Offences are alleged, my lord, allegations are there. That the investigation will reveal. But when the matter pertains to documentary evidence, my lord.
Yes, maybe the custodial interrogation necessary, my lord, because here one victim is there, my lord, from how many victims, and those, my lord, all these things need to be, my lord, inquired into detail, my lord.
Nowadays, still that it is a 7 year.
7 years.
7 years. Yeah.
So whether 35 will be required or it was not issued, I think.
Not issued. They called me once, my lord, I went.
Seems that what was saying that modus operandi is that you are not adjusting the earlier loan
My lord.
amount, and that has been misappropriated.
Yes, yes. Yeah, directly involved otherwise. Considering that aspect, my lord, whether how the my lord reasons can be cited by the IO or the police for whether if they have served or notice. Still now there is time to serve the notice under section my lord 35(3).
So, my lord, if they serve a notice, I will appear, my lord. On that point, my lord, the understand is submitting that if they serve a notice, I will appear. I have already appeared once. If they further serve a notice, I will appear. Only when I don't appear, my lord, and I don't cooperate with the investigation, then in terms of 35(6), my lord, I can be arrested, my lord.
Yes, my lord, because because custodial interrogation is required. In suppose police issue notice and now they are under protection, then definitely police will not arrest them. Will not be able.
Okay. Is subject of it that being not recovery as a bank. The amount which is credited to UPI in his account and which was subsequently credited in the bank. The sections which have been incorporated in this case are admissible under for 7 years, and petitioner had already appeared for the as he was called for, and extended his scope. He was again asked to appear before the police station on
Date has
station
not been.
on the next. Mr. Nawaz however submitted that he have not received any notice under section 30 from the police. So he is still ready and willing to extend his cooperation in the investigation. Next paragraph, Mr. Bott is submitted in this that from the FIR is simply said that the present accused petition being a recovery agent in collaboration with the other accused who is the branch manager of the bank had misappropriated huge amount of money from the borrowers only with the pretext of giving new loan and adjusting the earlier loan, adjusting with the earlier. Instead of adjusting the earlier loan, they have misappropriated the entire amount, and thus there is a financial loss to the institution. Mr. Bott accordingly submitted the interrogation may be required for the purpose. Hearing this section, considering the nature of the offense as well as also considering the fact that the petitioner had earlier cooperated with the I, this court is and that one more chance may be given to the present petitioner to extend his cooperation in the investigation of this case. Accordingly, this court is of interim protection may be to the present petition till receipt. Okay, will be under interim
My lord.
protection.
And on my lord, 26 of May.
Behind the bars, my lord. And page 10 is the FIR. Now, my lord, the petitioner before your lordship, my lord, is a brother and sister. When allegation is that, my lord, page 10, my lord, is the FIR. May I read, my lord? With due respect, I beg to state that I, Dipsika Das, daughter of so-and-so, a physically handicapped woman, and Kamal Chandra Roy, son of so-and-so, was in relationship since last 7 years and has made physical relationship in the pretext to marry me and has aborted me so many times by giving me some kid mother. After that, I came to know that he is a married person and his wife left him for domestic quarrels. And when I came to know and wanted to break the relationship, then he has threatened me to commit suicide and has mentally harassed me. And in the absence of anyone in our house, he came to our house and has made physical relation with me forcefully, and I became pregnant. And after that, he promised me of court marriage by divorcing his earlier wife. In the year 2022, his wife so-and-so filed a 498A case against me and Kamal, and he has taken an amount of rupees 40,000 from me for bail. In the year 2022, April, he has taken an amount of rupees so-and-so to purchase a glamour bike. For driving license, he has taken an amount of rupees so-and-so. In the year 2022, he has taken an amount of rupees 60,000 by saying that he will go for work with his friend, but he stays with his wife at Abhaipuri. In the month of September 23, he has taken an amount of rupees so-and-so. Basically, 22 has taken an amount of rupees 2,20,000 by saying that he will purchase an eco van bearing registration number so in her name. But on the contrary, he has taken the vehicle in his name. In the year 2024, he brought a Realme 5G mobile, and by forging my mother's signature in her check, he has withdrawn cash. From July to 24, he has maintained a secret relationship with a married woman from a village. And when I came to know about the incident, he assaulted me and has broken my mobile. In October 2025, he uploaded my photo in Facebook and has also written my defamatory statements. In 2012, 2025, accused, now my lord, the petitioner, Bhodreswari Roy, has assaulted me and has tried to kill me and by strangulating my neck and has told me that you lame, you handicapped person, why are you staying with Kamal? Leave him, and has also given many ill advices to Kamal And when Kamal says that she will take recourse of law, then she threatened me of dire consequences and will set fire on me and my mother's house. In this regard, I approached the police so many times, but on 21/26, Kamal Roy has given a written promise in North Bongaigaon PP stating that he will marry me by divorcing his first wife, Dhananjay Roy, where Motilal Roy, Manoj Roy, Namita Roy, and accused Bhattacharya were the witnesses. From the day he again made physical relation with me, and suddenly on 22/20/26, he stopped contacting with me. He used vulgar messages to me, and he blocked me on 17/2/26. Everyone of our village came to know that he stays with the accused Bhattacharya Roy. On 25/2/26, and there was a meeting in presence of the president secretary of village, my lord, but he was not present and was avoiding the brother of the accused, Manoj Kumar Roy. He has kept Manoj Kumar Roy, my lord, brother of Bhattacharya, has kept Kamal hidden in a house, and Manoj Kumar has given ill address. The allegation is against Kamal. Now Kamal is arrested. Forwarding report I have annexed. The allegation against them is basically 351 criminal intimidation. Nothing else. An allegation of 69 and 89 promise to marry and miscarriage is against Kamal. So against us, there is nothing, brother, sister, and Manoj is a government employee, the petition number 2, আপু বলবেন।
Page 35, my lord. In view of the above last paragraph, you are hereby directed as follows. Immediate suspension of further placement of guidance overbearing using the current methodology. Submission of a revised method statement incorporating enhanced safety measures, including but not limited to so and so. And so you are not asked, he was asked not to proceed any further work until the revised method is reviewed. Then your lordship will look at page 38. Page 38, your lordship will find the sequence of events leading to the collapse, my lord. Your lordship will see the precast post-tension guider of land so-and-so, bottom flange so-and-so, casted in the casting yard, followed by post-tensioning. After completion, the guider was transported using a gantry truss mechanism to span number 12. The guider was being lifted and positioned at bearing level on 15 April 2026. During the lifting operation, a mechanical failure occurred in one of the hydraulic jack used for positioning the inner guider of the upstream side, as reported by the executive engineer Jonai TRD. Consequently, the inner guider lost stability, pushed the adjacent upstream outer guider, and both guiders at span number 12 collapsed to the ground. Then your lordship will turn to the page 39. In regard to education of design, staging, and launching arrangement, the design has been approved by the Chief Engineer, PWD, Border Roads, and NEC Work. Then role and responsibility of officers and contractor, your lordship will find. As reported by the Executive Engineer, Jonai TRD, although the contractor staff, the technical person of the concerned division and technical staff of the third-party quality monitoring consultant, Messrs. So-and-so, were present during the position of the guider and were continuously observing every stage of the operation, the incident could not have been prevented. The collapse occurred due to a sudden mechanical failure of the hydraulic jack, which was beyond human control. Then your lordship will look at page 40. It is a detailed inquiry done, and ultimately at page 41, the finding came that it was due to a mechanical failure of the hydraulic jack. Now, your lordship will see why we are apprehending. This apprehension is, my lord, at paragraph 10 of page 9. Paragraph 9, page 9, paragraph 10. That following the occurrence of the said incident, certain local organization and members of the public assembled at the site and expressed a grievance by way of protest against the contractor responsible for execution of the. In view of such public agitation and prevailing circumstances, there is a reasonable apprehension that the petitioner, being government official, assured the project may be unnecessarily implicated. That to the best of the petitioner's knowledge, next paragraph, no FIR has been registered till date in connection with the incident dated 15/4/2023 involving collapse of two PSC guiders during the launching stage of construction of RCC bridge number so-and-so. However, in view of the media coverage and administrative developments surrounding the incident, the petitioner have a reasonable and bona fide apprehension of being implicated and arrested. The petitioner responds then so-and-so. So this is the only apprehension we have, Malab, because the local people, Malab, they are threatening the contractor. They are coming to our office every day, getting a sin. That's why we are before all the departmental enquiries, everything is in our, is that this incident had occurred due to a mechanical failure. Now the question arises, Malab, your lordship knows only that whether if an FIR is not registered, then whether I can be granted clearance bail. I would refer only one judgment of the Honorable Supreme Court, my lord, the recent judgment. Your lordship will kindly look into it. This is 2025 SCC page 1, Shushila Agarwal versus State and City of Delhi. Paragraph 2 Delhi. Paragraph 91 at page 109. Your page 109, paragraph 91, final conclusions of the court. Your lordship got. Now, your lordship would kindly see 92.1. This is a law which is always there, my lord. 92.1. Consistent with the judgment in Gurbakh Singh Sivia versus State of Punjab, when a person complains of apprehension of arrest and approves for order, The application should be based on concrete facts and not vague or general allegation relatable to one or other specific offense. The application seeking anticipatory bail should contain bare essential facts relating to the offense and why the application reasonably apprehends arrest, as well as his side of the story. These are essential for the court, which should consider his application to evaluate the threat or apprehension, its gravity or seriousness, and the appropriateness of any condition that may have to be imposed. It is not essential, my lord, this is important. It is not essential that an application should be moved only after an FIR is filed. It can be moved earlier so long as the facts are clear and there is reasonable basis for apprehending arrest. It may be advisable for the court which is approached with an application under section 438, depending on the seriousness of the threat of the arrest, to issue notice to the public prosecutor and obtain facts, even while granting limited interim anticipatory bail. My lord, in similar cases, my lord, where a coordinate bench, my lord, we also came for in a different nature. This is only for persuasive value. Your lordship is not bound by any order of a coordinate bench. Your lordship will see. Next page, my lord. The officer in charge of so-and-so is directed to file a report as to whether any FIR has been lodged against the present period. It is further directed that till disposal of the application by this court, police shall not arrest the petitioner so-and-so in respect of the incident that so-and-so and decide maneuver so-and-so. So we also want a limited protection for a limited days, that since no FIR has been arrested, let the officer in charge file a report. Till then, my lord, we may be protected by this honorable court, my lord. And my lord, why these officers are necessary? Because any trader, if they take leave and leave those station and all, because now is the flood season going on. All these officers have to monitor the flood in the Dhemazi area and all. So that's why I'm praying that your lordship may fix a date for the officer in charge to file a report. And till then, my lord, I may be protected by this officer.
DRD, my lord, technical persons, my lord, to look after those, my lord, works. So, my lord, they are responsible for, they are entrusted with the execution, supervision, and monitoring of those, that project, my lord. And otherwise, my lord, here, one page 37, till now, my lord, at present, my prayer before lordship, I may be allowed to get a report from the IO, whether any case registered. Probably, my lord, considering the seriousness of the offense, my lord, case may be registered, my lord. So I will, then, my lord, I may be allowed to get the instruction, my lord. And earlier also page 37, my lord, regarding the, my lord, not only, my lord, shifting of the burden cannot be only, my lord, shifted to the contractors, my lord, because contractors are doing their works, but they are the technical persons, my lord. They had to visit the, my lord, site, my lord, to look after the entire work, my lord.
My lord, with utmost respect, these are all presumptive submission made by my learned friend. The reports and the inquiries are in our favor. We said that it is a mechanical failure. It was an accident. It can happen, my lord. Sometimes the railway takes all protection, but still, my lord, there are train accident, my lord. But here, my lord, no, the departmental inquiry has not attributed any negligence on the part of the officers of the PWD department, my lord. That's my respectful submission. And they are government servant. There is no chance of abscondent. If any case is registered, they will cooperate with the investigation. Further any custodial detention may not be necessary at this stage till the FIR. Delay report. All reports are in our favor, my lord.
Finding materials that they are the responsible person.
No, there is not even a one line against any of the officers. Others I would have pointed it out to my lord.
From which judicial police station?
Silapatar. Silapatar in regard to the incident dated 15/4.
Silapatar is under which?
Dhemaji.
Dhemaji.
And one person is a cancer patient, my lord. He is just after 6 months in Bombay, he returned, my lord.
PD court, senior advocate, assisted by
P. Dole.
P. Gogo.
P. Dole.
P. Dole.
Dole.
P. Dole did an counsel for the petition. And they also heard Mr. P. Additional PP appearing on behalf of an application seeking anticipatory bail connection with anticipated bail, uh, anticipating and registration of a case under syllabus. Yes. Damages. This next right submitted to Mr. Bond.
28 মিনিট নাই মই
That all these accused
29 মিনিট লব পাৰিম
are the responsible officer of the PWD department. PWD department. Unfortunate incident that happened when two person fell down into a river bed for sudden all of the hydraulic check when the work was in progress. But these petitioners are very involved in the state of their the officers, and the entire project work was done under the guidance of the contractor. However, all the petitioners are ready and willing to extend their cooperation in the event of registration of any case, or if they call for immediate investigation. Next paragraph, Mr. Court, this PP submitted in this report that the report may be called for from Silaptar police station as to whether any case has been registered against the present petitioner in connection with any case due to collapse of the hydraulic project as stated. Next, hearing the submission made by Lane considering all other aspects of the case, this court is of opinion that some interpretation may be provided to the present petitions till the receipt of the report. Accordingly, the police officer from the Silapur police station is hereby asked not to take any coercive action against the present petitioners. However, the petitioners may approach and cooperate with the investigation of this case in the event of registering any case. Pardon, the additional people, Mr. Waterford will take all initiative to call for the report from concerned police station. Next, when it can be listed, what they will be under interview.
Learned senior want to fix it on 29th of May.
29th of
May.
So it will be prior to that you don't
Prior to
have
that
any.
on my 21st also, I think 20.
Okay, then
20
25th can be
21st, yes, sir. 21st.
21st.
Yes, ma'am.
Okay.
Obliged, sir.
Thank you. So, yes.
482 application, Lordship. Lordship, petitioner is the probation officer of Punjab National Bank, who has been posted in Nagaon, Berhampur district. Unfortunately, on 28/4/2026, husband of a CSP holder, CSP means customer service point, committed suicide. And being I am a probation officer and management training, I have to visit all the CSP. And it's a village area. There's a rumor that I have some relationship with the wife of this deceased. That's much, Lordship. And there is no suicide note recovered and nothing, Lordship. And on the pressure of the public, police is searching me, Lordship. Till date, till returnable date for report, I may be protected, Lordship. And furthermore, I am engaging in the election duty, Lordship, as a micro observer.
GD entry has already been made.
GD entry is there, Lordship.
Industrial outpost is under which police station?
Nagaon police, Lordship.
Nagaon Sadar.
Nagaon Sadar.
It seems prima facie that my lord, probably your lordship may kindly come to my lord, paragraph 5, my lord.
Paragraph
Yes, paragraph 5 to 8, my lord. That Oniman so-and-so, Rajiv Bora, son of so-and-so, committed suicide at his own residence, leaving no suicide note implicating anyone. Then, my lord, paragraph 8. This is Rajiv Bora was not happy with the job of his wife Debashree Gogoi Bora. Further, he was suspecting his wife. Unfortunately, it is stated that unemployed person, he has been arrested. for which he has been arrested many times.
Arrested many times, drug addict.
That the accused deceased had tried to commit suicide on 16/6/23, but fortunately he was rescued. So well, everything regarding that is also well, probably in this case, case already has been registered. Well, I will have to get the instruction. Well, it seems well, Prime Minister.
A report may be called for, Lordship, till then I may be protected, and if anything is implicated in this FIR, Lordship, definitely I will cooperate. And kindly consider, Lordship, I'm election micro observer, Lordship. So counting is going on in Nagaon district, so I have to have there, Lordship. And I'm a probation officer, so any arrest may hamper my career also, Lordship. And then no way involved in this suicide case, Lordship.
But Mr. Akesh, the cost for the petition. Also for Mr. P. Bottom, the application of the state response. This is an application under section 482 PNSS, being for PNS bill. Suspecting any registration of a case under in Itashil outpost under Nagaon suburb. Submitted by Mr. Sharma that police from the Itashil outpost is searching for the petition after suicide committed by committed by one of the. I mean, how you are related? He committed suicide. So his wife, who may lose the FIR.
Their family members may lose their FIR, Lordship.
Paragraph 10, my lord.
Family members may lose their FIR, Lordship.
One person unfortunately committed suicide, and the family members of the say deceased person are trying to implicate the present petitioner in the behind the deceased suicide. So the petitioner is no way related in the no way related with the deceased.
That's a low piece.
Next point, Mr. Potter put in an additional PP submitted in district that one GD entry has already been made under the Churchill outpost, and hence the outpost, and from the and in the statement made in the present petition also, and there are materials that which may be materials to for registration of a case against the present petition. Mr. Potter accordingly submitted that he may be called, he will call for a report from, and he may be allowed to call for a report from the Itasil outpost under Nagaon PSO and raise objection for any interpretation. Here is submission made by land council for both sides. Let a report be called for from Itashil outpost as well as the Nagaon Southern PS as to whether any case has been registered against the present petitioner behind the commitment of suicide by the deceased. Further, considering the submission by Mr. Sharma, let police for the Itashil outpost as well as in Nagaon Sadar PS is hereby asked not to take any coercive action against the present petitioner till receipt of it. When it can be called for?
On my lord, 19th of May.
19th. Will be some interim protection, no coercive action shall be taken against.
Deeply understood.
Yes.
May I please, Lordship? It's a petition under section 520th BNSS, Lordship. Here in this case, Lordship, we have challenged the order of the learned trial court whereby charges under section 1031 of the BNS have been, Lordship, framed, Lordship. That we have challenged. At best, it could be a case of, Lordship, 105 part 2. So, Lordship, at this stage, Lordship, notice may go, Lordship, and the scanned copy of the TCR may be called, Lordship.
You are how many petitioners? One.
Four petitions.
Four petitioners.
They are standing trial for the offense of 1031, Lordship.
But at the time of framing charge, they have not raised the issue, those issues, which have now we have raised.
No, we have raised issues.
That was not considered.
That was not considered. Lordship, you can see page number 54.
This discharge application was
Discharge
rejected.
was rejected.
Heard Mr. N. Hasan, he done it for petition. Also heard Mr. B. Porterfoot, he done it for PPA on the steps. It's an application 528 BNSS. With section 438 of the 442. Paying BNSS, paying for washing off and setting aside the implement order. Dated 12/12/25. Passed by learned petition session judge FTC number 2. Tinchukia in sessions case number 142, packet of T of 2020, whereby discharge petition referred by the petitioner issue notice to the respondents to speed post and usual process. However, no formal notice is required to be served on the petitioner, the key respondent, state respondent number 1. The requisite copy may be served during the course of the also call for the scanned copy of the DC. You want any fixed date or after 2 weeks will do?
After 2 weeks will do.
The demand will be accordingly listed after 2 weeks. As on a date to be fixed by the registrar.
Obliged.
May I please, Your Lordship?
Yes.
But in this revision petition, my lord, we have challenged the import order, my lord, whereby convicted the petitioner, my lord, under section, my lord, 279, 304A and 427 IPC, and sentence him for 2 years, my lord. In that, against the conviction order, we have filed an appeal before the learned session judge, my lord, that was rejected and after the conviction order. In this case, my lord, the one person subsequently has been died, my lord, due to alleged accident, my lord. I was the driver of a motorcycle, my lord, knocked on the father of the respondent number 2, and subsequently he died in the hospital. But the prosecutors had failed to examine the doctor and also failed to exhibit the post-mortem report, and also failed to examine the MBI officer, my lord. So, my lord, there is serious doubt how the deceased was died, my lord.
At this stage, will notice may be issued and
Hi, Mr. R. We done it. Counsel for the petition, also part Mr. B. Board so and so. And this is an application, section 442. Related section 528 BNSS against the implement judgment and order. Dated 26/03/26. Passed by learned session judge Baksa, Mosalpur, in criminal appeal number 19 of the 25. And dismissing the appeal and upholding the judgment and order dated 31/05/25. Passed by the learned CGM Baksa, Mosalpur, in PRC case number 181 of the issue notice to the respondents, no formal notice is required to be served and so and so. Also call for the DCR. The estimator accordingly after 3 years as on a date to be fixed. Where is your eye?
There is an I, my lord, for suspension and allowing to his on paid bail.
Present day, he is on in previous bail or?
No, my lord, the learned appellate court directed to surrender before the trial court. Page number 23, my lord.
So you have not moved any application before the learned appellate court? You could have moved an application before learned appellate court, intimating
madam.
that you are going to prefer a revision before the high court.
No, but the learned appellate could direct it to my lord surrender one. Page number 23.
I also my lord notice maybe issue scan copy.
No, if he got arrested, then
Wait 3 years.
if he got arrested during the pendency, then maybe in difficulty. That's why I'm saying.
Yes.
I mean, he is the convicted for 2 years. So if you have any objection, you can submit.
Yes. Concurrent finding of the trial copy. Let's scan copy of the PCR maybe.
And next date is, you just tell us. When is your next date is fixed?
Otherwise,
Next
direction is
date
there
was
to-
not given, my lord.
Direction was given.
Direction only.
But when direction was
That-
given, it was received by the learned trial court below, I think.
Yes.
Lordship.
And is there any date is there?
Lordship.
Because case record was
Yes.
returned back to the learned trial court below with
Lordship.
a direction to the accused that you surrender before so and so for to go through the punishment and all. But learned trial court below will also fix a date, no? Is there any date?
No, no, madam.
No, he will feel, okay,
Yes. Ma'am.
he will definitely give you a time to surrender before or for this things.
So,
So now what is the stage before the trial court? I
so
just
now
want to
he has
help you
not
because
complied
if
with the
this
direction
date
of the
is,
trial court. Madam. So now he is out of the my lord jail because now he has not complied with the direction of the trial.
not compliant.
The trial. Session.
Because, my lord, the 90 days, my lord, learned trial court directives to surrender within 30 days. There is a limitation period of 90 days before approach before this or not.
30 days is okay, they have
Yes.
submitted. I am just asking you, what is the position of the trial
No,
court below now?
I have no knowledge.
Should know, because if there any date is fixed,
Yes.
asking you to surrender, there has to something.
Lordship.
Because this record is accordingly returned back. You were asked to, or whether NBW may also be issued.
Yes.
There has to be something, nah? That's
Lord.
what I'm asking.
Lord.
You are not aware of.
No, no.
So he is not in even in previous bail. So question of bail will not come in suspending.
In that case, when do you want to release? You just try to get these things. I mean, what is the order passed by the learned trial court below this thing to get it? Will
Later also he can file an application before the session court. Madam.
at present, most probably at the time of passing the order of during that period, it ought to have been filed as we
Yes.
are going to prefer a revision before. So your petition would have been considered by the learned session judge.
Not finally.
You have did not avail that opportunity also.
And regarding that.
So
also-
can we list the IS simply on the
Lordship.
in order column? It will be listed. Any issue notice go to I have to do order column on it. Get a fair file. On 13th only.
Lordship.
Scan
Otherwise,
copy.
we listed your revision after 3 weeks, but it will be listed after on 13th.
Lordship. Lordship. Public.
May please, Your Lord. Lordship, this present petition has preferred its revision under section 19(4) of Family Courts Act, Lordship, by assailing a order passed by the Honorable Principal Judge Family Court, Nalbari, whereby he has been directed to pay a monthly maintenance of ₹3,000, Lordship. Before, shall I take your Lordship the whole judgment or only the relevant portion?
Relevant portion you can.
Lordship. Lordship, may kindly come to page number 25, internal page number 6. Para 2.5. Currently, she is taking shelter in her paternal house. The second party has not contacted till date and has not provided any maintenance. That is the allegation, Lordship. In the next page, Lordship, in 3.1. The second party stated that a social marriage was held with him according to customs on so and so, and it is true that at the time of marriage no dowry or strident was required. Although utensil ornaments were brought partially by the first party voluntarily after the marriage. The said item were taken back by the first party, but the allegations of quarreling with the first party over small matters and physical and mental torture are false. He stated that he lived in a rented house in Gauhati but did not torture first party. Now, on the next page, page 27, 3.3. It is important also. The second party further stated that he had sent a notice through his advocate so-and-so on 17/9/24 to the first party to resume their conjugal life. But the first party, even after receiving the said notice, has not given any importance to it and has not returned to his house. Thereafter, he has filed a restoration of conjugal rights case, which is under adjudication with the above. The second party prays for dismissal of the case. Now, for a woman, lordship, if I would like to take your lordship in the next page, page number, lordship, 33 onwards. Internal page number 14, lordship. Point number 2, lordship. Whether the second party is sufficient source of maintain to first party, and in spite of that, he have neglected to maintain the first party. Here, lordship, the petitioner for lordship has never neglected. In fact, he is willing to lead his conjugal life. It is the wife who has left the house of the petitioner lordship. To that extent, I will just take your lordship to one application which was preferred by the petitioner before his release on the date on which she wants to go out of her conjugal life, lordship. In the first page is the application filed by the petitioner lordship. In the second page, lordship will find প্ৰতি মাননীয় কথাকাৰ ছুপাৰ ৰাইজৰ আজি নিবেদন 3 বছৰ আগতে মোৰ কিশোৰী কলিতাৰ লগত মোৰ বিবাহ হৈছিল। এই বিবাহ বিভিন্ন কাৰণত পৰিত্ৰাণ বিচাৰিছো। সেয়েহে মই স্বইচ্ছাই সুস্বাস্থ্য মগজুৰে এইখন স্বাক্ষৰ কৰিছো। উল্লেখ্য যে মই মানসিক অশান্তিও পাই আছো। এই কথাষাৰে ছুপাৰ ৰাইজৰ কিশোৰী পৰিয়ালৰ মোৰ যাবলৈ বাধ্য কৰা নাই। It was a signature, and lordship, this document has been exhibited as Exhibit 1 by the petitioner lordship, which is very much evident from the judgment lordship. And page 34, lordship, the trial court itself come to a conclusion that the petitioner at present he is only a private tutor at his native place at Haribanga, and his average income would be around 14,000. It is the presumption of the made by the land trial court lordship. And the second party is directed to pay a amount of 3,000 per month, despite of the fact, lordship, which was not considered by trial court. Now I would like to just take your lordships to page 18 for a moment, Annexure B. Several litigations are pending between the parties, lordship. The Annexure B, a DV case, lordship. Agreed person is present, respondent 1 is present, respondent 2 and 3 are absent with steps so and so. Heard both sides on prayer of interim maintenance. Land counsel by agreed parties stated that if lordship allows me, let me skip lordship the second last paragraph, lordship. After hearing both sides and considering aspects, it appears that both parties are living separately since 18/8/2024. That is on which this letter was executed, lordship. And it is bounden duty of the husband to maintain his wife, his legally married wife. The respondent side has not filed any affidavit on assets, expenditures, liabilities. Hence, considering the aspects, the respondent number 1 is directed to pay maintenance of rupees 2,500 per month as interim maintenance until further order. So, lordship, since 10/1/2025, the petitioner has been paying a maintenance of rupees 2,500 to the wife till date. And lordship, at the instance also, he is not saying that he will not pay, but the amount is agreed by the amount, lordship, and the land trial court has failed to discuss about this maintenance. Despite the fact that while filing the assessment liabilities as well as Rajnesh versus Neha, the petitioner herein and the respondent both have stated in the assessment liabilities that a amount have been he is receiving an amount and he is also paying an amount, and the land trial court has failed to bring on has quoted nothing to that sort of thing, that he is already paying an amount. And
how can we know that till now you're paying?
Lordship, the
You do not.
the trial court records will reveal, Lordship. The trial court record
No,
will
no,
reveal.
in the DB case, you're submitted, in DB case, you are paying. So where from?
No, that was admitted by the wife in her cross-examination, Lordship. In her person, she herself admitted that she is receiving an amount of rupees 2,500 as maintenance from the date which the court has granted her. Directed the petitioner to pay her, Lordship. At this stage, Lordship, my limited prayer would be, Lordship, that if Lordship previews the orders at page 36, he was directed to pay all the area amount, Lordship. I am just, my limited prayer would be, Lordship, notice may be issued at this stage, TCR may be called for, and Lordship, the area amount may be state. And if Lordship pleases, Lordship, the quantum may be reduced for the time being.
Quantum, how can it be?
The area amount may be state, Lordship,
Hard
for the
to
time being,
guess.
Lordship.
And Krishna Nayatra, the Learned Counsel, and also hard Mr. And also, sorry, they're supposed to. This is an patient. '94 of the Family Code Secretary Section 438, only 442, and 528 of BNSS. Against the impute judgment and order between 1903 to 6. Passed by learned principal just before Albert in abstract criminal case number 35 of it, whereby the petitioner is directed to pay a monthly maintenance of rupees 3,000 only to the respondent from the date of filing, that is with effect from 10/9. Issue notice to the respondent, to the sole respondent registered through speed post and review process, and also call for the TCR. Next paragraph, it is submitted by Mr. Krishna that the accused petitioner, the petitioner is also paying rupees 2,500 as per order given in the DB proceeding since 10/1/2025, which is also admitted by the respondent in her. But at the time of passing the order, the learned principal judge does not consider all these aspects of the vis-a-vis the assets and liabilities of both the parties. Accordingly, he submitted that till disposal of the present petition, the area amount which is already accrued with the accrued upon may be stayed till may be stayed. Next, hearing this submission made by learned counsel for both sides. And the learned counsel for the petition, and considering aspects of the case, let the area amount accrued on the let the area maintenance amount be stayed. However, there is no stay order in payment of the monthly maintenance as ordered by the learned special judge family court. No. Let the matter be accordingly listed after 3 weeks. After 3 weeks, as an date to fix. Your area and amount has been stated.
Deeply. The TCR may be called for.
Yes, we are calling.
Deeply.
Yes.
My lord, this petition is directed by the order of the learned session judge, by which, my lord, an amount of 20% was directed to be deposited for the purpose of, my lord, suspension of the, my lord, sentence in an NI Act case, my lord. Lordship finds, my lord, at case 17, my lord, the impugned order, my lord. Has your lordship got it?
Yes.
My lord, appellant is duly represented by his learned counsel, hardened learned counsel for the appellant and peruse record. Finding scope of interference in the impugned judgment and conviction dated so-and-so passed by the learned additional so-and-so Sonitpur in the connection with NI case number so-and-so. The appeal is admitted for hearing subject to payment of 20% of the fine compensation amount to be respondent.
further proceeding of the impugn judgment on so and so is stayed till disposal of the instant appeal. Now, my lord, that portion, my lord, we are agreed by that portion, my lord, because my lord, as your lordship is aware, my lord, after Jambu Bhandari's case, my lord, that 20% has been stated not to be mandatory, my lord. And my lord, if my lord, the learned court below insists on the deposit, my lord, an exceptional circumstance has to be carved out and that has to be stated and recorded why it is so necessary. my lord.
No, other side. Exceptional circumstances you have to brought in if you do not want to pay. Is there anything?
That
But
is why,
otherwise, I won't say it is a mandatory.
my lord.
But as per provision of most probably 138,
148,
148 or
148, 148.
you have to pay.
Yes, my lord, the direction is there, my lord, but the direction in the
But the
case
question is that
thereafter in
if you don't
Puskan.
want to pay, if there is any other reason, that has to be if you're
No,
in a
no, but
petition.
my lord,
instead.
into my understanding, my lord, after Jambu Bhandari, my lord, and thereafter in Muskan, my lord, what was contemplated by the Supreme Court was that, my lord, if my lord, because under section 389, the language in Jambu Bhandari is that, my lord, when somebody applies for a suspension of the sentence and stay of the order, my lord, he applies 389 with full rigor, my lord, not with any conditions. So now, my lord, that condition, to apply that condition, my lord, the learned court has to see whether that is necessary or not necessary, my lord. And if, my lord, it finds necessary, why it is necessary, that has to be, my lord, mentioned, my lord. In my respectful submission in this order, my lord, that has not been mentioned, my lord. And, my lord, in the entire case, my lord, if your lordship sees the impugned order also by which I was convicted, my lord, my case was that, my lord, by force, my lord, I was, my lord, made to sign in those checks, and thereafter, my lord, I went to the police station. The police also did not register a complaint because those people were powerful people, my lord. And ultimately, my lord, I had to face the trial and the court, my lord, disbelieved me on that count. And that is why, my lord, if your lordship kindly sees that order dated, my lord, 17, my lord, which is impugned here, finding scope of interference in the impugned judgment and conviction dated so and so. So, my lord, the learned court below had applied its mind. It's not just that I had preferred an appeal, and because it was in first appeal, my lord, so then it was, my lord, directly then and there it was admitted. So, my lord, it appears that the learned court below had, my lord, applied its mind to the facts and circumstances of the case and on the evidence and as well as on the, my lord, judgment which has been rendered. That is why it says that finding scope of interference, my lord. So the scope of interference is there, and I have stated, my lord, I am in a penurial condition, my lord, I don't have money to pay, my lord. As it is, my lord, this case is, my lord, a false case which has been thrust upon me. And thereafter, my lord, I seek the, my lord, protection of this court, my lord, that part of the, my lord, may kindly be, my lord, set aside, my lord, and I may be continued with the appeal, my lord, what will happen?
State is partner 1.
Yes.
State is 1, my lord, but otherwise,
Probable
my lord, their notice will go to the respondent number 2, my lord, I have made him a party also.
Otherwise, my lord, judgments on both sides, my lord, word may is there, my lord, from that section.
May is
That
there,
is discretionary,
shall, may, there.
but I would like to point
judgments
out,
are
but
there.
there are decisions of the Supreme Court that may shall be treated as sales.
Now,
And
ultimately, it is
suppose-
Muskan, my lord, Jambu Bhandari and Muskan, and then, my lord,
Yes,
there
my
are
lord, Jambu Bhandari and Muskan.
Muskan, my lord.
I would just
And
like to point out.
Muskan is very detailed, my lord.
Jambu Bhandari also said that, my lord, 148 is discretionary, but for that you will have to file appropriate application by stating all those grounds. Why that need to be waived, my lord?
Why that need to be
reduced?
waived? Is there any
Yes,
peculiar conditions?
those grounds have to be placed.
there.
Yes,
But they have not filed any petition.
yes, that is required, my lord. Without getting all
Even we
those
were not
grounds,
asked at that point of time because, my lord, some lawyer, my lord, they
When the order was
preferred the
passed,
petition
you
because that is why
you
the
could have
concept
filed a
of
petition for waiving those 20%.
to have filed, my lord, not filed, my lord, not filed now, my lord, what can be done, my lord, that cannot be undone. So, my lord, that is why, my lord, perhaps, my lord, seeing that position, that concept of 389 CRPC was brought into Jambu Bhandari, and where it directly says, my lord, that, my lord, when we file a petition under 389, we file it to apply all the rigors of 389, not conditional, my lord. That was recorded in Jambu Bhandari. So at this stage, my lord, let a notice go, my lord, and till that date, my lord, they repair and the other side appears, my lord. And lordships, my lord, hears us on the matter, my lord. Let that part be kept in abeyance, my lord.
otherwise, your lordship may also direct that let them file an appropriate, my lord.
Yes, my lord, lordships can
by
do that, my
stating
lord,
all
today
those
itself in
grounds,
both the cases. If your lordship passes a final order, my lord, I can go and, my lord, I can appear before the court,
and whether
giving
that
the
can be-
liberty, yes, my lord. That can be done, my lord. I have no objection to that.
Mr. G. Chaudhary, the learned counsel of the petition. Mr. B. Watercook. This is an application, this is petition, 438 and 442 PNSS for PNSS against the order passed in a revision dated 2303 26 in, no, order passed, sorry, order passed in criminal appeal number 04/2026, dated 23/03/2026, by which the decision session just had imposed a condition for payment of 20% of the fine of the compensation amount to the respondent. Subject to stay of the implement order passed by the learned trial court below, dated 24/04/2026, convicting the accused appellant under section 130 of the
He has submitted that it is not found on record. How could that be always to
issue notice to the respondents. No formal notice is required to be served on the state response number 1. And however, a requisite copy may be served during the course of the day. Also call for the DCN. No, also call for the scan copy of the DCN. However, next part, considering the submission made by Mr. Chaudhary, the order of payment of 20% fine of the compensation amount to the respondent is stayed till next return. Let the matter be accordingly listed after 3 weeks. After 3 weeks, as on a date given.
Let it be up to 4 weeks.
4 weeks.
Then
4 weeks
notices
as on
will
a
go.
date given.
In both the cases, 15 also it is the same, my lord.
Yeah.
15
also
same
stayed.
order, man, same order. Only the name of the party will be different. Petitioner is the same. Respondent number 2 is different, my lord. Same order.
4 weeks going through. How many cases are pending against the present?
Only these 2 cases, my lord.
Still only these 2 cases.
These 2 cases, my lord. Deeply only.
PP applicant reported. It is submitted to Mr. Waterford that today morning only case diary has been received. Accordingly, he needs some time for perusals. In view of this, the matters be adjourned. Fix it on 12, then can it be 12? We're listing it on 12.
Yes. Obvious.
Made please, your lordship. Made
Yes,
please, your
Chief.
lordship. My lord, in this matter, I have agreed with an order passed by the family court, my lord, directing the petitioner to pay an amount of rupees 9,000 maintenance, my lord, in 2 grounds, my lord. That is, one, my lord, the respondent is an earning lady, my lord, as she is a practicing advocate, and also he is discharging duty as notary public, my lord, appointed by the government of India. And secondly, my lord, the respondent is staying away from the matrimonial home without any sufficient cause, my lord. As such, my lord, the order is held here before your lordship, my lord. The order passed by the Learned Family Court is at page 57, my lord. We have, my lord, the Honorable Court considered the fact that the object of the maintenance proceeding is not to punish a person for his past neglect, but to prevent vagrancy and destitution of a deserted wife has been observed, but that principle has not failed to apply the upon that particular fact, my lord. That's why before your lordship, my lord, at this stage, my lord, notice may go, and as the lady is an earning lady, my lord, may I pray for stay the operation of this order, my lord, judgment order. My lord, regarding the maintenance towards child is, I have no problem, my lord. I will pay that part, my lord. But I have objection aggrieved aggrieved with that portion, my lord, whereby direction has been given to me to pay maintenance to my earning wife, my lord, who is practicing advocate. She has not mentioned anything about her practicing as advocate, my lord, in her petition as well as in evidence. But she mentioned that she is earning 15,000 as advocate in her affidavit of assets and liabilities, my lord, wherefrom he admitted that she is earning. But she suppressed that fact in petition and evidence, my lord. And it is not impossible that an practicing advocate who is also practicing as a notary public has earning only 15,000, my lord. She failed to produce any material to prove that she is earning 15,000. As such, my lord, may I pray for your for issuing notice and stay the operation of this judgment till final disposal of this petition, lord.
Second, then application finding for PNSS against the challenging the judgment and order passed by the learned principal judge by the court. In FC criminal case number 537 of 2024, whereby the petitioner is directed to pay rupees 9,000 per month towards maintenance for the respondent and rupees 4,000 towards maintenance of child. The second further submitted that while passing at the time of the crime, the respondent has suppressed the fact that she is a practicing advocate and also appointed as a notary public. Though she admitted that she earns rupees 15 per month. Mr. Saikya further submitted that he has no objection to provide maintenance to his child, but his objection in maintaining in paying the maintenance amount of 9,000, when the respondent is a working lady and earns more than 50,000, which will be sufficient for her maintenance. Next, issue notice to the respondent and also call for DCM. Further considering issue notice to the respondent to speed post and process. So call for the DCM. Further considering the submission made by land consideration, he is directed to pay rupees 5,000 per month till the disposal of the connected till the disposal of the present. And list the matter accordingly after 3 weeks is on a date to Yes, 17.
May I please, as your lordship? My lord, this is a matter regarding, my lord, Jimma of certain articles, my lord. So first of all, my lord, I was a business, my lord, operating a business of, my lord, livestock. While I was in a transportation of, my lord, 25 numbers of buffaloes in a my lord, mechanized licensed vehicle, my lord, there is no, my lord, objection as regards my vehicle that had been intercepted by the, my lord, Kotkoti police station, my lord, and a case had also been registered subsequently. And, my lord, thereafter I have filed my Jimma petition under, my lord, the provisions of the BNSS, my lord. Now that Jimma petition.
Jimma for vehicle or
Jimma for vehicle as well as the livestock also, my lord, that 25 numbers of buffaloes also, my lord. So, my lord, I beg to draw my lordship's attention, my lord, to the order by which the Jimma had been allowed, my lord, can straight away can take up page number, my lord, 68, my lord, annexure 2, my lord. Annexure 11, my lord. at page number 68, Milord.
Yes.
Milord, may I be permitted to read, Milord? Case record is put up on the strength of a Jimma petition number date has been filed by so-and-so praying for Jimma 25 numbers of black-colored male buffaloes with ear tags. One Isar truck bearing registration number so-and-so along with key, one Isar truck with registration number along with key, one registration certificate by registration number so-and-so in the name of the petitioner, one trading license by number so-and-so in the name of the petitioner, one certificate of so-and-so. My lord, may kindly note that the one certificate of health soundness to the 16 numbers of male buffaloes issued by the veterinary assistant surgeon dispensary, Nuland, Nagaland, and one of the health soundness of 9 numbers of buffaloes issued by the veterinary assistant so-and-so, Herd and Peruse. The learned counsel for the Jimma petitioner has submitted that the above for which the Jimma have been prayed for are seized in connection with the instant case. On perusal of the case record, it is seen that as per the seizure list so-and-so, the above items in question were indeed seized by the police. A statement of the seized properties under section 497(2) of the so-and-so is prepared and the same is annexed herewith. In a recent judgment of the Honorable Gauhati High Court in State of Assam versus so-and-so, held that the word investigation as defined in section 2A so-and-so is different from the word so-and-so. So, my lord, this is the judgment which is reported had been quoted, Milord. And after this, after the Indian Penal Code is repealed, actually, Milord, it is should be the CRPC should be repealed, and the BNSS speaks in the same manner in section 106 subsection 3 of the Act. Therefore, section 106 subsection 3 2 gives power to the police officer to give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required and to give effect to the further orders of the court as to the disposal of the same. In this case, my lord, may kindly, this paragraph is important, my lord. In this case, the petitioner produced the copies of registration certificate of the vehicle, certificate of health soundness issued to the Brahmaputra goat, all cattle supply livestock where the legal owner being the petitioner, trade license issued by the Gauhati Municipal Corporation, Gauhati, and related documents in his name. Prima facie, it appears that the petitioner MD Rafiqul Islam is the rightful claimant of the properties concerned. So, my lord, there is a subjective satisfaction of the Lord Honorable Learned Trial Court below, my lord, that this I am the, my lord, the claimant, rightful claimant of the petitioner. Now, my lord, the trouble arises from this paragraph, my lord. IO of the case is directed to pass necessary order on the Jimma 25 numbers of black-colored male buffaloes with ear tags, one Isar truck bearing registration number so-and-so along with the key and so-and-so, my lord. The entire description have been given. One trading license, the entire has been directed, my lord, but the rider which has been given, my lord, is at the last paragraph at page 71. The IO may give the custody to the petitioner MD Rafiqul Islam in case it is not required for investigation on proper verification of the documents. Now, as a result, my lord, the IO, as it has been, the power has been entrusted to the IO, my lord. Now, the IO is saying that my verification is not over, so I cannot give custody or the Jimma of the vehicle to you, my lord. So, this is in, my lord, complete, my lord, violation as regards, my lordship is well aware, my lord, regarding the judgment of the Honorable Apex Court also. And I will, my lord, my lord, may kindly peruse the another subsequent application which I have preferred, my lord, before the Learned Trial Court below, my lord, is at page 73, my lord. My lord, I did inform regarding this situation before the Learned Court below. The Learned Court below recorded by order dated 22/4/26. Case record put up as prayer is made by so-and-so, Govind Kakoti, not to release the seized 25 numbers of buffaloes till the completion of investigation as the ownership of the buffaloes still could not be ascertained. Now, my lord, this is a one kind of application for reviewing the order of the Learned Trial Court below by the IO. So, my lord, this itself appears, my lord, some, my lord, not very, my lord, bona fide approach of the Learned, my lord, the trial court officers, my lord, because the demand is very extraneous, my lord, and which is very difficult to, I cannot pronounce before my lord regarding that demand, my lord. So, therefore, my lord, the SI says the Govind Kakoti reported that the matter is pending for submission of the documents by MD Rafiqul Islam but he has not produced the documents yet, my lord. The police record itself reveals, my lord, the entire documents whichever is required, health certificate, purchase certificate, everything, my lord, I had already been submitted, which is also a part of the record before my lordships also in this petition, my lord. Now, my lord, this says that since the document have not yet been verified, the IO may give custody of 25 numbers of buffaloes to the petitioner on consideration of the valid documents in his name. The IO so-and-so is directed to furnish a report of his finding after perusal of the documents. Now, my lord, the learned trial court below has itself, my lord, one kind of review of the earlier direction which has been given, that the power again has been entrusted to the IO. It had been directed that, okay, you go for the investigation and submit the report, my lord. So, my lord, therefore, this entire, my lord, the proceeding which has been, my lord, instituted before the learned trial court below is appears to be, my lord, by dehorse the provision of the Jimma, the ratio of law, my lord, which has been fixed by the Honorable Apex Court as well as by our Honorable High Court also, my lord. I am just troubling my lordships, my lord, with a very Lord, recent
The
order.
question just I'm want to
My
ask
lord.
you whether you have produced this health certificate. Those were produced, undoubtedly produced before the court, and that was satisfied by the court.
Lord,
We are not on that.
no, yes.
Yes, but
yes.
thereafter, when you're like going before the approaching at it before the IO,
IO, my lord.
produce all these documents.
Yes, my lord. It is on their record. Even, my lord, those documents has been seized. Those documents which the IO is saying that I have not produced, it is in the array of list of the Caesar list also, my lord. Those documents has been recorded by the IO, my lord. Apparently, my lord, this statement of the IO is not, my lord, tallied with the records, my lord. Is absolutely false, my lord. My lord can verify from the Caesar list which I have annexed, executed by the IO himself, my lord. My lord, there is nothing as such, my lord. If I fulfill the demand before the IO, by overnight, my lord, my buffaloes will be released, my lord. That is the instruction I am receiving, my lord, which is very high. They are asking that we have already spent more than 1,500 rupees per day per buffalo. So therefore, you have to pay minimum 15 lakhs. Then only your buffaloes will be released, my lord. This is not my fault, my lord. You have illegally taken custody of the buffaloes, my lord. So it is your duty to feed them. And even, my lord, the buffaloes are not put in the Sarkari Gosalas, my lord. It has been put in a privately managed Gosalas, my lord. And we have come to know that IO himself is the owner of that Gosala, my lord. Such type of racket is going on, my lord. So therefore, my lord, if my lord may be pleased to take up this just for a moment, my lord, the judgment of the Honorable Apex Court, my lord. My lord, I am reading the very first page, my lord, then I will come to the relevant paragraph. Help, my lord. The power under section 451 CRPC should be exercised expeditiously and judicially. It would serve the various purposes, namely, owner of the article would not suffer because of its remaining unused or by its misappropriation. Now, my lord, in my case, what has happened? The buffaloes are weight more than, my lord, near about 90 kgs and 100 kgs, my lord. Now it has been reduced to 40 to 45 kgs within this month, my lord. That is the instruction. So they are now going to, my lord. If another 10-15 days remain there, then few of the buffaloes are going to be, my lord, died, my lord, due to their deplorable condition. There is no at all condition to keep them alive, my lord. This is the situation. Secondly, my lord, the Honorable Apex Court has also observed that the court or the police would not be required to keep the articles in safe custody. If the proper panchnama before handing over possession of article is prepared, that can be used in evidence instead of its production before the court during the trial. Now, my lord, these buffaloes are not required to bring to the court to produce them before the magistrate, my lord. It can be, panchnama can be made, and those panchnamas can be used also, my lord. So this is the, my lord, relevant part, and my lord can take up the relevant paragraph. I am troubling, my lord. It is in para 7, my lord, at page number, my lord, 288. May I read, my lord? Para 7. In our view, the power under section 451 CRPC should be exercised expeditiously and judicially. It would serve the various purposes, namely, so and so same has been reiterated, my lord. And this jurisdiction of the court to record evidence should be exercised promptly so that there may not be further chance of tampering with the articles. The question of proper custody of the seized article is raised in a number of matters in so and so versus so and so. This court dealt with a case where the seized articles were not available for being returned to the complainant. In that case, the recovered ornaments are kept in a trunk in the police station and later it was found missing. The question was with regard to the payment for those articles. In that context, the court observed as under so and so. My lord, this has been reiterated. And so, my lord, the object of the court, I am reading from the last few line above, my lord, of the court seems to be that any property which is in the control of the court, either directly or indirectly, should be disposed of by the court, and a just and proper order should be passed by the court regarding its disposal. In a criminal case, so and so, the police always acts under the direct control of the court and has to take orders from it at various stage of an inquiry or trial. In this broad sense, therefore, the court exercise an overall control on the action of the police officers in every case where it has been taken cognizance. So, my lord, the very ratio of law, my lord, my respectful submission before my lord is that, my lord, the very ratio of law is that the immediately it should be, my lord, released and there should not be any debarment for all these properties should be kept in custody, my lord. Now, in my case, my lord, if something happens to these buffaloes, my lord, untoward, then, my lord, the entire burden will shifted upon the state, my lord. Then they have to bear the expenses or the cost of the properties also, my lord. So it would be better, my lord, by executing any terms and conditions, my lord, or any bond, they can, my lord, release these properties, my lord. So therefore, my lord, these very orders which has been passed by the learned trial court below, the first one with a rider and the second one, my lord, is with a one kind of review of the earlier order, my lord. Both orders are, my lord, not in connivance with the very spirit of the Jimma provision, my lord, as well as the ratio of law fixed by the Honorable Apex Court.
My lord, here, kindly tell us the second order passed by the transport in 2026. My lord, first, second, third, fourth, my lord. Since the documents have not been verified, the IO may give custody of the 25 numbers of buffalo to the patient Mohammed Penso on consideration of the released documents in his. That is one part. Second part, my lord, next para, my lord. As the safety of the 25 numbers of buffalo IO so and so, directed to keep the 25 numbers so and so, that is, furnish a compliance report, my lord, on 27/4/2026. Here, that next date was fixed on 27/4/26 for report, my lord. What happened, that is not here, my lord. And here my submission is that Lordship may call for report, compliance report from the IO. Why he has not complied the order of this court matter. And I will produce that report. Direct the IO produce a report within a short period. Compliance. Whether he has verified the document and what step he is taking. Considering the seizure.
My lord, may I be permitted, my lord, to bring my lordship's kind notice to page number 37, my lord. To, my lord, counter my learned friend's submission regarding the verification of the documents, my lord. This seizure has been done by the police IO himself, my lord. This is the entire list of the seizure. My lord, this is the articles which has been black color, white buffaloes bearing. This, my lord, these buffaloes are always, my lord, comes with a, my lord, tag in their ear, my lord. My lordship knows, my lord, for the proper identification. So entire 25 numbers buffaloes along with the tag numbers has been mentioned in serial number A to 25, my lord. Then B, the truck bearing registration number along with key, driver Hakim Bhuya. Then, my lord, next page, one is here, one registration certificate, one trade license, one certificate of health soundness so and so, veterinary, one certificate of health soundness so and so. So, my lord, these are the entire documents which are required for the, my lord, legalize and, my lord, transportation of this type of business had already been in the custody of the police and they have already been verified. Now, my lord, why this action has again been taken by the police, that what is the requirement for the further verification? It is also not, my lord, explicit in the order that I have not verified the document earlier or nothing, my lord. It is just a, my lord, pure case of police harassment against the petitioner, my lord. There is nothing as such that I am not doing this business illegally, my lord. No records or no order of the Honorable Court has held that, my lord. The Honorable Court in fact held that I am the person concerned who is entitled, my lord. In paragraph at page number 70, in second paragraph, my lord, says that it appears that the petitioner is the rightful claimant of the properties concerned, my lord. This is the findings of the learned trial court below, my lord. So thereafter, keeping my property in such a manner, my lord, is a clear violation of Article 19(1)(g), as well as, my lord, Article 21 has also been infringed with, my lord. So therefore, my lord, my lordships can pass an order, my lord, directing to release the vehicle, at least these buffaloes, my lord, with certain terms and conditions, my lord. If required, I will cooperate with the investigation, my lord. What is there, my lord?
Is 37, they charge a minor articles. Is article. Just say it will be verified, man, whether these are the original or not. This is the legal. Although it is in the order, it is reflected, man, but from the order itself, man, this 72, man, I said that it was not verified. He himself said it was not verified. That was compliance code was called for on 27/4, man. Already over that, over my on that, what is that is not a record, man. And perhaps if it is submitted the compliance and there is nothing of therefore, I say for a report directly the IO submit a report regarding compliance to the order whether verified or content line I prefer for the
Administrator, done it senior.
NZ Chaudhary. NZ Chaudhary.
And each, and J. Chaudhary, they done it. Also, Mr. B. Sharma, they done it. Should be approved. It's an application. Section 438, with section 442 and 528 of BNSS for modification and public order. Setting aside the order dated 8/04/2026 and 22/04/2026 passed by learned SDGM Okajan in Jimma petition number 10/2026 arising out of Gauhati PS case number 31 of 2026 concerning the release of 25 numbers of buffaloes and vehicles. Vehicles is also not been released till date.
No, my lord.
Next, Mr. Mr. Punyani Ranit Senior further submitted that while dealing with the Jimma petition, the learned trial court below, while its order dated 8/4/2026 had discussed in detail regards to the seizure and the documents which were produced. Your earlier 8/4 number is where is 8/4? 8/4 order is at page?
Yes, yes, my lord. It is page 68, my lord.
Page 68.
68, my lord. Starts at page 68. Annexure 11.
Yet. And discussed in detail about the registration of certificate, other certificates of the vehicle, as well as the health certificate, soundness certificate, etc. 16 numbers of male buffaloes and 9 numbers of 16 numbers of buffaloes. Numbers of buffaloes were 16 or 25?
No, no, my lord. 9 plus 16, my lord. 9 plus 16, my lord.
9 plus 16.
My lord.
25 numbers of buffaloes. And the time of hearing all the veterinary, the certificate issued by the veterinary assistant surgeon, Nagaland, etc., were also produced before the learned trial court. So, considering all these documents, including the seizure documents which has been discussed in the order, the learned trial court below had observed that the present petitioner and the present petitioner is the rightful claimant of the properties concerned, including the vehicle as well as the 25 numbers of copies. With that observation, the learned trial court below had allowed the prayer for Jimma, but it was further directed, but it was directed, but I was given a direction to give the custody of the custody of the properties concerned, which were seized, and the properties concerned with proper verification and documents.
Very good. Very good.
But on subsequently,
Very good.
when the petition appeared, the registration certificate is also already there, no? Only
Lord,
for now, you're pending for only
only for the
cattle.
buffaloes, my lord, cattle only. The vehicles and other articles has been handed over to.
Thereafter, on approach made by the petitioner, the vehicle and other seized properties were already been released in favor of the petitioner. However, the IO submitted a report before the learned court below that
Page 73.
yes, that if the documents in connection with those buffaloes, that is the medical certificate, etc., were could not be verified by the IO, as those documents were not produced before the before the IO concern. Accordingly, the IO concern in that context, it is submitted by Mr. Raman Bhuyan that the court had earlier made an observation regarding the genuineness of the claim of the present petitioner, but subsequently, by order dated 22/04/2026, had made a review of his earlier petition and directed the IO to give the custody of 25 numbers of buffaloes on consideration of the valid documents in his name, which is not permissible. Accordingly, he submitted that the order passed by the learned trial court below, dated 8/4/2025, particularly the last para, wherein the I was directed to verify the documents, as well as a order dated 22/04/2026, needs some interference, as till date even after approach of the petitioner, the 25 numbers of buffaloes were not released in favor of the present petition. Next, Mr. Sharma, the learned additional PP, submitted in this regard that it is a fact that the vehicle as well as the buffaloes were given Jimma to the present petitioner by its order dated 8/4/2026, but from the order as by the learned trial court below, dated 22/04/2026, it reveals that in spite of the direction, the petitioner did not appear before the IO with appear before the IO with all the documents, and for which those could not be verified. And accordingly, the case was also fixed for 27/04/2026 for a compliance report for the I. But there is no mention as to what had happened on 27/04/2026, 27/04/2026, when the compliance report was asked to furnish by the I. Mr. Sharma accordingly submitted a compliance report may be called for from the IO as to whether what steps has been taken by him or as to whether any verification has been done by the IO for release of 25 numbers of values. Next, but considering this submission made by the council for both sides, data detailed compliance report be called for from the IO concerned as to whether the petitioner had produced the documents and as to whether the after verification and as to what as to whether the IO has complied with the order of this court, the order of the learned trial court below dated 8/4/2026, vis-a-vis and dated 22/04/2026. Later detailed compliance report be called for according to we were short date.
Friday lolo. Or even all
Friday may not be possible.
Monday or Tuesday?
Monday can be, yes. Monday.
11.
Or if suppose you did not receive the report by Friday, you make a communication with the IO,
Today.
concerned IO
Today
through
tomorrow I-
telephonic conferences. We'll see. Monday report.
Taken by the date.
Monday.
Monday. 11. 11.
obliged, madam, deeply obliged.
Monday, 11.
That
Yes.
please your lordship, my lord. Improved order page, my lord, annexure 8, page 42, my lord. May I read, my lord?
Yes.
First party has appeared and filed petition number so and so, stating that second party filed a petition by so and so, dated so and so, concealing the fact that he was contracted second marriage in the year 2024 without divorcing her, and he filed FC case so and so and obtained the expiry degree on 28/7/25. Therefore, it is stated that the second party cannot take the benefit of the said expiry degree, and second party may be directed to pay maintenance as the husband and degree dated so and so passed in the case. I have heard the first party in person. She may file appropriate application under order 9 Rule 38 for setting aside the expiry order in suit. Second part, the second party has not appeared and paid the maintenance, so NBW be issued against him. First party shall take 2026 for a payment and appearance. That this is a single date, my lord. The petitioner was absent. He is a by profession driver, my lord. So on that particular date, he was absent. So that is why, my lord, this NBW.
You are not agree with the NBW,
Yes.
not with the rest part of the order. Because in the other part of the order, your expertise which have already obtained is also.
At this stage, my lord, on next date, fix the case for payment and appearance, my lord. NBW was issued, my lord. I am ready to pay, my lord. Background of the
Why
case.
it has been discussed that you have suppressed the matter, you took the
Yes,
divorce degree, etc. Those she may file an appropriate application under order 9 rule 13 for setting aside the expertise.
Background of the case, my lord. The respondent number 2, my lord. Respondent number 2, my lord.
Only order you have annexed.
Respondent number 2 filed this maintenance petition in the year of 2023, my lord. And accordingly, contesting the case, the petitioner filed WS and evidence. Thereafter, final order was passed, my lord. But in the same year, the present petitioner filed title suit, my lord. My lord, registration of conjugal right, my lord. After hearing this matter, expertise degree and order was passed in favor of petitioner, my lord. I have all the documents I annexed, my lord. So,
You got the degree in your restitution of conjugal rights.
Yes, my lord.
Now what are you doing?
Though, my lord, the respondent appeared single date, my lord, thereafter
No,
was
with that,
absent, my
with
lord.
that decree, now what are you doing?
I have
you
submitted, my lord, I have
to bring
submitted.
her back?
I have submitted this degree, my lord, before the learned court below, my lord, which was pending FC criminal, my lord, Barpeta.
Have you,
31
thereafter, it is only a paper degree or you have taken any steps
No, my
for
lord,
bringing her back?
no, my lord, I have submitted and also order was passed, my lord. Kindly see, my lord. Kindly see, my lord.
Now see, you have submitted that NBW was issued.
Yes, ma'am.
Earlier order, you have not annexed any order. So how can we say this is the first order? Or your absence was only for one day? From where we will see now?
Kindly see, my lord, Annexer 7, my lord, page 40, my lord. After
So that's
submitting
why
this order, my lord.
now question is see, page 40 is an order on 30/01/2026. Order was passed.
Yes.
When you have brought before the notice to the court that we have already
Yes, yes.
obtained an ex parte decree
Ex
for
parte degree.
restitution of conjugal rights. You have submitted one ex parte decree order before the court.
Yes.
That I have already obtained the ex parte order decree, isn't it?
Yes, my lord.
But the court in the next para, in the court number, page number, para number 4,
Yes,
it has been seen that the parties when so the final order of this case was passed on 5/8/2025. So thereafter, what you have done, we are not in a position to say anything.
My lord, I am regularly paid, my lord. My lord,
So bring some order then.
regularly paid, my lord. Only single date, my lord. Single date I
That
have
is your
absent, my lord.
submission.
I am only single date I have absent, my lord. I am a driver, my lord.
I can
I
understand.
am ready to pay, my lord.
Yeah.
Kindly consider, my lord. On the next date, I will pay, my lord. Here, my lord, discuss.
No, that is your submission that you are paying, you will pay. But where from will get? There's no order. Because now see, the question is that the order of this court, order in the your maintenance was passed on 5/8/2025 itself. That is 5/8/2025. So from 5/8/2025, there are many dates has already been gone.
Yes.
So we are not in a position to say whether any order was passed in between.
Here, my
Why
lord.
NBW was
In this
issued.
case, my lord, in this FC criminal case, my lord, after submitting this ex parte order, my lord, decree and judgment, the order was passed, my lord, filing of the case to 23, my lord, in the year of 23 FC
Yes,
criminal.
an order was passed on
Since
5/8/2025.
Since then, order till my lord, till my lord, 27/8/25. In this period, my lord, maintenance was directed, submitted by the petitioner.
Furnish all the orders. He furnished all the orders, relevant orders. Now see, from your submission, from your record, we are not in a position at all to
Stated, my lord,
whether there was any payment was made or not.
I am stated, my lord,
How from where you are saying, see, from where you are saying that payment was made, or you are regularly paying. There is no order at all.
well, I am stated, my lord, in my.
So it is your submission.
Yes.
It is your
Yes,
statement.
yes, ma'am. Yes, ma'am.
Where from we'll know?
Yes,
That is
ma'am.
what is what I am asking.
I will appear, my lord. I am ready to pay, my lord. Some arrear was pending, my lord. I will consider, my lord. On next day, I am definite. I am ready to
No,
pay.
you file the order sheets. File the order sheets for your cancellation of your this NBWA can be stayed. There's no issue, but
Yes.
no order is there. Since when you are absent,
as
since
per
when you are
instruct-
not paying, we are not in a position.
As per instruction, my lord, and I
This is your
stated, my lord,
instruction. This is your submission. There is no order. I'm repeatedly saying this is your submission. This is your statement. I can understand.
Yes, my lord.
But there is no order.
Yes, my lord, I am not.
You just do one thing.
lord. Just, my lord.
When the next date is fixed,
Next date, my lord, 8/5, my lord.
8/5.
8/5.
Before 8/5, we are not in a position to fix any date. What about priority of management? Who better for the 8/5 por agora aqui. Okay, then we're listing it on 7th. Do one thing, collect all the order sheets, orders, order sheets, etc., whatever, to an additional affidavit you file, submit before us, we'll pass the order.
Very short date, my lord. If the honorable.
On one hand, you are saying you require short date, and on the other hand, you are not. We are fixing it on 7th. Your case is fixed on 8th. So prior to that, we are fixing 7th. Somehow we are fixing on 7th. We don't have any date.
LCR may be called for my lord. Washing the NBW, my lord.
He's not. You are not
I am
following what
ready
I'm
to
saying.
pay, my lord. I am ready.
We want to give a relief. That's why I'm saying that you just file it through an additional affidavit all the order sheets. If you call for a case record, then it will take 1 month. We can make it. No issue. If you say that we should call for the case record, then we can call for. No issue on that. Will be after 1 month.
Okay.
What I'm saying, you just file the order sheets from where at least we can know that in regularly you are paying.
Yes, ma'am.
You are repeatedly saying you are regularly paying.
Yes.
When the order was passed in year 2025.
Yes. Yes.
But NBW had to be issued by the court. So there must be some reason.
Yes. Yes. Only single
One day,
document.
immediately NBW stopped the case because order was passed on 25. So I just want to see that whether in between you are paying, you have paid. Their order has to be there, no? There will be order that you have paid some second party had paid rupees so and so, but maintenance. This kind of order will be there.
Yes.
So in between from order passed by the court, that is on 25/8/2025 until date, if there is any order, you just submit the order to an additional affidavit.
Okay.
That will be accepted. That's what I'm saying. Okay. Yeah, about it. How do I do? Like this. Very short date we are giving on 7th.
Okay, 7 million.
7 month? 7th of this month, yes.
Eight, my lord, next date before this court, my lord, court, 8, my lord, 8/5, my lord. Yeah. Yeah.
Okay, 7/5. File an additional affidavit. Yes.
Lordship, this is a criminal petition. This is a criminal petition seeking recall of NBWN proclamation of attachment issued against the petitioner. Now, Lordship, the petitioner was shown arrested in an instant case and he was allowed to go on bail as well. So accordingly, he was under the bona fide belief that his engaged counsel was taking steps. But on 26/07/2023, the engaged counsel failed to take steps and accordingly NBWA was issued. And on the next date, 16/11, PNA was issued. So, Lordship, another point is that the same counsel was engaged for a different case of the petitioner in front of the same court, whereby NBWA was also issued and he sought for relief before this honorable court. And this honorable court, right, order dated 23/04/2026, passed in criminal petition number 567/2026, which is annexed as Annexure E at page 44, was allowed the petitioner to go on bail. Therefore, the same relief is sought, Lordship.
So by criminal petition, you want to quash the order, bail, what do you want?
For recall of the NBWN.
Recall only.
Yes,
then why you're insisting on bail then? Yes, since when the order was passed?
26/7/2023, NBW was issued.
Aripa.
Thereafter, my lord, Lakshmi kindly told last order. Here, my lord, page 43. Here, the quote below one, considering all I deem it fit to declare the accused person is a proclaimed offender. Hereafter, last part, my lord, it appears to me that attendance of the accused person could not be procured soon. Fixing the case day by day to day will only burden the court. Therefore, the extent case is filed against the accused person till his appearance in court is put. That is order also 18/5/2024. That what happened, madam, the case is alive or not, madam, that is not.
It was most probably filed. How many accused persons were there in the case?
Against him it was filed.
Against
No,
how many you
in the FIR, my name was not there. I was shown arrested subsequently.
so there are other accused
Yes,
persons also. Case is under which section? Basically 420, 406, 468 was also there. Yes, 468 is 18/5 is the last order.
18/5/2024.
Prior to that, any order sheets are there?
No, there are not in order.
No, prior to that.
Prior to.
There are some orders. So your NBW was issued since 26/7.
27.
26.
2023.
The prior to that, BWA was issued. You earlier you got bail.
Yes, sir.
At the time of framing of charge, he was present. Order dated 6/12/2020.
Page 33.
Page
6/12.
6/12/2022.
Page 32. Page 32.
Hmm.
Thereafter, he was there.
RMS P. Ora, Dilane competition. Also part P. Sharma, Dilane. Dated NSS Washington order dated 26/07/22 and the subsequent orders, including the last order dated 18/05/2024, passed by the learned GMFC Gauhati in connection with PRC case number 145 and 21, issuing NBW and ENA against present petition. Submitted by MS Bora that the present petitioner was shown arrest in connection with this case, and thereafter he got bail and was regularly appearing before the planet track. The charge was also accordingly framed on 6/12/2023. But thereafter, why you were absent?
Lordship, the petitioner was under the bona fide belief that his engaged counsel was taking due steps.
Thereafter, he was under the bona fide belief that his engaged counsel is taking steps on his behalf. The engaged counsel did not make any contact with the petitioner. hence he was unaware about the proceedings and the dates fixed by the learned man. However, coming to know about the evidence of NPW and PNA against him, he immediately appeared in his court with a prayer for recalling the order as stated above, and is ready and willing to appear before the learned trial court below on each and every date to be fixed by the court and to contest the case. Next, Mr. Sharma, the learned submitted in this that after framing of the charge 6 to 2, the is that the accused petitioner remained absent with stay in some days, and thereafter he did not appear before the learned trial court below, for which by its order dated 26/07/2022, the NBWA had to issue against the present petition. But thereafter, despite the issuance of the NBWA, petitioner did not appear before the court, and for which by order dated 8/5/2024, the receipt of the second finding no adultery, the court had to issue NBWA along with the PNA, and by order dated 18/5/2024, considering the report on PNA and NBWA,
accused was not found in the
and the accused, no, he- PNA, wherein it is reported that the accused was not found in the said locality, comma, the learned trial court below, finding no other alternative, had to issue standing warrant against the present petitioner, and case was also filed against him as day-to-day fixing the case on day-to-day basis did not serve any purpose. Mr. Sharma accordingly raised objection and submitted that it is not a case that only NBW was issued by the learned trial court below, but considering the return of the NBWA without execution on several occasions, comma, the order on 18/5/2024 had to be passed, and hence there cannot be any reason for recalling the order of issuance of NBWA as well as the order dated 18/5/2024, which has been were required by the case against the present petitioner was filed. Next, for hearing the submission made by learned counsel, I am also perusing the annexures, especially the order sheets filed along with the petition. It is a fact that initially the after release of the accused, he was appearing, and charge was also accordingly framed on 6/12/2022. But there, on many occasions, the accused remained absent, and for which the NBWA had to be issued by the learned court bill on 26/07. But in spite of issuance of the NBWA, the attendance of the petitioner could not be procured, and for which, finding no other alternative, the learned trial had to issue PNA against him. Thereafter, spring the report of the PNA, finally the order of finally the case was filed against the present petitioner by issuing standing warrant against him. Thus, it is seen that the learned trial court will had made every attempt to procure the attendance of the present petitioner, and only after filing of the case and Coming to know about the issuance of standing warrant, petitioner had approached before the court, wherein he remained absent since more than 3 years. Huh?
What?
6. About 3 years. Considering all these aspects of the case, this court is of opinion that the recalling of the order of with this court is of opinion the learned trial court below had rightly passed the orders, and hence interference of this court is not at all necessary. However, the petitioner is hereby directed to surrender before the learned trial court below with a appropriate application for bail, and in that event the case may be reopened, and considering the ground for his absence, the appropriate order of bail may be passed in order of bail may be passed in accordance. Thus, the petitioner is hereby directed to immediately appear before the, because now case has already been filed. We don't have any case now.
For others, it may be also closed for evidence.
So he has to appear.
Right.
And on his appearance, if his bail is considered, then it's okay. Otherwise, after 3 years, what to do? Case has already been filed. Now, yes, it is not a case that his case is against him is pending. It's already been filed.
Yes.
So let him appear. Ako deal with again. I repeat with someone again. So you just appear. We have already discussed. You have shown arrest. You are appearing around the view that written that your petition, the advocate is taking steps. These are all have been mentioned in the order. You just appear because case has already been filed against you. This both.
May I give you, please? My lord, in this case, my lord, we have approached before this court, my lord, for quashing of my lord, NBW, my lord. My lord, what happened, my lord? In this case, my lord, the petitioner was, my lord, regularly appearing before the court, my lord, till my lord, my lord, 17/12/2024, my lord, that is page 19, my lord, in exam 5. Thereafter, petitioner, my lord, could not appear with my lord, absent, my lord. My lord, kindly see, my lord, page 19, my lord. Order dated 17/12/2024, my lord. My lord, till that, my lord, till my lord 17/12/2024, my lord, petitioner was, my lord, regularly appearing before the trial court, my lord. Next date, my lord, fixed on 25/3/2025, my lord. On that day, my lord, petitioner was absent with steps, my lord. My lord, which was fixed on 11/6/2025, my lord. On the 11/6/2025, my lord, petitioner was absent, my lord, without steps, my lord. And that is why, my lord, NBW was issued, my lord, without recording any reason, my lord. The reason, my lord, absent before the trial court, my lord, was, my lord, the petitioner is a DUS level, my lord. He went for Kerala for livelihood, my lord, with the discussion with his, my lord, engaged counsel, my lord. But he did not take any steps, my lord, and that is why, my lord, NBW was issued, my lord. My lord, I am ready to face the trial, my lord. So, my lord, I may be directed to appear before the court. In the meantime, my lord, impugn order, my lord, 11/6/2025 and my lord, 19/3/2026 may be issued, my lord. Next date fixed, my lord, 7/5/2026, my lord. This is my humble submission. Yes.
Absent without any. That case, on the evidence.
And my lord, till that, my lord, no PW has been examined till that, my lord. Because, my lord, they were also, my lord, absent. Yes, my lord. Yes, my lord. In the meantime, my lord, impugn order may be issued.
Within 10 days.
Yes.
Oh, not 20. 7/5 is it?
Yes, my lord. On 7th, my lord, may I will appear.
You are Mr. Hussain?
My lord.
Part Mr. A. Hussain, the learned counsel for the petitioner. B. Sharma, the learned petitioner. State respondent. Then applicant under section 528 BNS institution or against the impugn or against challenging the impugn order dated 11/6/2025 and order dated 19/6 passed in sessions case number 63 of the 2022 by learned additional session plus FTC number 3 Kamrup M. Quality, whereby non-bailable warrant of arrest has already been issued against the present petition. Next, it is submitted by Mr. Islam that the present accused petitioner was regularly appealing before the learned trial court bill. And on 17/12/2024 also, he was present. However, no witnesses were turned up, and the next date was fixed for evidence on 25/3/2025. On 25/3/2025 also, he was absent with stay, and on his behalf, a petition was filed by his and his counsel. Thereafter, the next date was fixed on 11/6/2025, but on that day, no steps was taken for the present petition, and the court issued, and the learned court below had issued NPWA against him, and on subsequent date, also the NPWA was issued in 1996. It was submitted that there was no intentional lapses on the part of the present petition, as he went to Kerala for his livelihood. His and his counsel did not take steps on his behalf. And for which the NPWA was issued by the learned trial court. He is ready and willing to appear before the learned trial court below and to contest the case accordingly if the order issuance of NPWA is recalled. Next, Mr. Sharma, the learned additional PP, submitted that from the order sheets annexed along with the petitioner, it seems that in two occasions the petitioner remained absent in the state, and NPWA was accordingly issued on 11/6/2000. Mr. Sharma, we submitted that the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance. Next, hearing the summary made by learned counsel for both sides from earlier conduct of the petition and other aspects of the case, opinion that a petitioner may be given one chance to appear before the learned trial court with a application for regular bail, which may be considered in accordance. However, till next date of listing, the NPWA issued against the present petitioner be stay.
Mine, obviously.
Make the motion. No, this is an NIA case, my lord. In this case, my lord, at the stage of defense evidence, my lord, after I gave my defense evidence, I gave a prayer to summon the IC of Niribagan police post because I wanted to prove the GD entry. So accordingly, summons was issued. I took steps. Multiple occasions, summons was issued, but the IC did not turn up. The last occasion, the court also reflected it in the order that I had taken steps, but abruptly closed the evidence, saying that the matter has been pending for a long time. So defense evidence is closed. Lordship, I'll produce all the documents, my lord. Your Lordship will first see page 21, my lord.
Yes. 21.
21. 21, this is the complaint, my lord. Complaint case was filed, and in page 22, the lordship will find the two check numbers, my lord. 1, 2, 3, 4, 5, 6, 7 line from bottom, my lord. 43437 dated 9/10/2019, my lord. And last line, my lord, 43438 dated 9/10/2019. So these are the two checks, my lord, dated 9/10/2019, which were dishonored, for which this case was filed, my lord. Now, your lordship will kindly come to page 20, my lord.
Page
20.
20.
20, my lord. So
Yes.
checks were dated 9/10, my lord. Here, almost 7 months prior to that, your lordship will see, on 7/3/2019, I had filed a complaint, my lord, and this is a police report, whereas serial number, my lord, your lordship will find 43433 to 43455. So almost 7 months prior to this case, my lord, the dishonor of the case, I had filed a complaint, and police had issued this report regarding this loss of the check, my lord. Now your lordship will kindly come to page 32, my lord. 32 is my 313 statement, my lord. And at page relevant portion, your lordship will find at page 34. The lordship has it, my lord. So here, do you have anything else to say, my lord? Here I have clearly stated that I did not borrow any money from the complainant. On 7/3/2019, I had visited the accused person as he deals with so-and-so. Hereafter, when I reached Nilbagan, I discovered that I don't have my bag and mobile phone with me. I returned to the house of the complainant in search of my bag and phone, but he denied that I left it in his place. Regarding this, I have lodged a complaint on Nilbagan PP on 7/3/2019. So this is, I have also stated in my 313 statement. Now your lordship will kindly come to page number 49. And this I also exhibited during my evidence, madam. While giving evidence, this report was exhibited, madam. Now at page 49, if your lordship will see,
Yes.
yes, hello, DW1. So I was cross-examined and discharged. Thereafter, I filed this petition. Accused person has filed a petition number so and so, praying before this court to allow the accused side to call the IC of Nilbagan outpost for exhibiting the GD in number so and so. The other has no objection. Prayer is allowed. Issue summons to Nilbagan outpost. So, my lord, I made this prayer. This prayer was allowed. Summons was issued, my lord, for the purpose of proving this GD entry, my lord. Now, my lord, next the orders, my lord. At next page, my lord. Complainant is present, accused is present, complainant is absent, accused present for DW. Next day, my lord, at 26/11, accused is present, accused side is strictly directed to adduce evidence on the next date, or else NO shall be passed. Necessary order, my lord. Now, my lord, 51, your lordship will kindly see, at 7/1/2026. Complainant is absent with steps, accused person is present. Steps were taken by the accused side, but no report is received. My lord, I have been taking steps for summoning the OC, my lord. Issue show cause against OC Hojai for not complying the order of this court. Next case's date is fixed on 7/4, my lord. Now, your lordship will kindly see at page 56, my lord. This order was passed on 7/1. At page 56, my lord, I have again taken steps. On 9/1, I have taken steps, my lord. Now, on the next date, my lord, this is the impugned order, my lord. Page 57. Complainant is present, accused is absent with steps, showing cause steps allowed, peruse the CR. On perusal of CR, it is seen that the case is pending for DW since 11/1/24. Till today, the accused side failed to secure the evidence of OC Hujai. Considering the same, the accused is given no more opportunity to adduce evidence. DW is closed. So, my lord, the police official, my lord, I cannot bring the police official on my own. For that reason, summons has to be issued. Police official will not come on my calling. Summons was issued. I was taking steps, your lordship. Order records are revealing that I have taken steps. Now, because OC is not coming, in that case, my lord, the court should have issued either a bailable warrant of arrest to secure the attendance of the OC. And there is also nothing to show that the summons were served. Straight away, just because the case is pending, defense evidence is closed. And this is within the jurisdiction of that magistrate, man. To the PI office also, the attendance of the police officer could have been very easily secured. But this was not done, and abruptly the evidence has been closed. Now, without the evidence, without the examination of the police officer, my lord, I cannot prove that GD entry. I am not the person who can prove the GD entry, my lord. So my limited prayer, my lord, is that an opportunity may be given, my lord, a direction may be passed to the court that the attendance of this witness be secure and his his evidence be recorded. I am not seeking any stay or anything, my lord, because this is the only thing, my lord. And through PI, it is very easy, my lord, because the police station is within like 5 kilometers from the court, my lord. Through, if PI it is sent, my lord, this attendance can be secured. My lord.
Next date was fixed.
Next date is fixed today, my lord.
Ah.
Next order is at page, my lord, 60. Case is fixed today for arguments. And the last date, the complainant I did not do. Today it is fixed for argument.
See, it is a formula.
Formula. Because I have not defaulted, my lord. I have taken steps on my own, my lord. Every date I have been taking steps. And that's because he is not coming. The correct approach should have been to take some coercive steps against the police officer for not complying with the code. In fact, the court has in fact issued a show cause notice also. So that should have been pursued instead of closing my evidence.
I think pending for a long time. In the order using order, it is
DW was pending till 11/1. Okay. Order, put order, take implement order
7/4/2006.
7/4. The DNI instituted complaint under DNI. Spanish put it on a track code below. Wherein the present accused petition had listed the case. That is the case. However, it is the plea of the petitioner that on which date you have
Lodged a complaint on 7/3/2029. 2019. It's 29.
7/3/2019. He had lodged a complaint before the police station regarding loss of his work bag was also there.
My lord, bag, phone, and ATM card.
Bag, mobile phone, ATM card, along with the
Checkbook,
checks, 2 checks in question. Accordingly, I also submitted a report in the in connection with this, wherein accordingly a GD entry was made. The police also furnished a report to that. At the time of his recording of statement on section 313 CRPC also, the the present petitioner, the same plea
Page 34, my lord.
the plea that he did not borrow any money from the complainant, and rather on 7/3/2019 he visited to the house of the complainant. No, you have visited where?
I had visited the
Agar.
this should be complainant. He has it has been wrongly
It's
written.
not there, and he visited to deal in Agarwood and Agarwood business, wherein and when he reached the Nilbaka, he discovered that he lost his bag and mobile phone and immediately returned to the house of the complainant. in search of his bag and phone, but he denied and then left his office and lodged a complaint before IC Nilpagan PP on 17/2019. Accordingly, the GD entry was also made, and GD entry was also thereafter. He adduced one evidence of one police officer.
No, no.
And also
No, no.
one police officer you have already
No,
adduced.
I have adduced only my evidence where I have exhibited. Madam. Page
Exhibited
36.
his own evidence and exhibited some documents, but thereafter he made a prayer before the learned trial court below to adduce evidence of IC Nilpagan PP to exhibit the particular GT entry which was made in the said outpost after he lost his complaint. The prayer was also accordingly allowed, and in free of vision, he also took steps for procuring attendance of the said police officer. But in spite of that, the police officer did not turn up, and for which the learned trial court below also issued a show cause notice to him. But instead of receiving any show cause reply or other nor still show cause reply, etc., the by order dated 7/4/2026, the evidence DW was closed and the matter was fit for argument. Next slide is submitted by Mr. Nawaz that if he did not give a chance for adducing evidence of said officer of Nilpagan outpost, the GD entry number, which is most vital document for his defense, could not be exhibited by him. He further submitted that he took all endeavor to procure the attendance of the police officer as a witness, but he could not make him bound to appear before the court, and there was no report at all regarding the service of the notice. But the learned trial court below, only considering the pendency of this case, had closed the DW. So was observed in the orders passed by the learned trial court below that the steps were taken for procuring the attendance of said police officer. Accordingly, Mr. Nawaz submitted that an opportunity may be given for attendance of the said police officer so that he can take the proper defense plea in the presence. Next, staying the submission made by learned the case record and the annexures filed along with the petition. From the record as well as the annexures filed, it is seen that the taking plea in regards to loss of his bag, petitioner had also adduced his own evidence with a further prayer for adducing the evidence of the in charge of Nilpagan outpost for
Exhibiting
the GD entry, which was made after receipt of his complaint regarding loss of his bag along with 2 checks. Considering suspect fact that it's to it is seen from the submission as well as from the record that the main plea taken by the defense plea taken by the present petitioner is that he lost a complaint after on 7/3/2019, which was accordingly and the GD entry was accordingly made by Nilpagan outpost, wherein he also lost his 2 checks, including the bag, while handset, and other relevant matters. If the petitioner is not given a chance for producing evidence of, if the petitioner is not given a chance for exhibiting those the said GD entry, the prejudice may cause to the present petitioner because that is the only defense plea taken by the considering expert. Considering this aspect of the case, the order by the learned trial court below dated 7/4/2026 is hereby recalled, giving and the court below is accordingly directed to give a chance to adduce evidence of the police officials from Nilbagan outpost. Nilbagan outpost. But you have already taken steps, no?
We've been taking steps, my lord. Lordship may record that they can route it to the PI office, my lord. That way it will be easier to procure the evidence.
Accordingly, the petitioner will also take fresh steps to issue notice on the police officials from the outpost, and that may be routed through the office of the PI for proper execution. And the learned trial court below accordingly will fix a date for the same and will give and the evidence of the DW2 will record accordingly by giving chance to the with the above petition the present.
I'm deeply obliged.
Made, Your Lordship. Made.
Yes, given. Yes, given. Wait. Yes, Mr.
Made, please, Your Lordship. Lordship, there is a 528 application, my lord. Lordship, had a look at page 53.
Yes, for which page?
Page 53, my lord.
Yes,
It
page
was a
53.
53, my lord. It's a summon, my lord, issued in a, my lord, complaint case, my lord. My lord, Lordship will see, my lord, whereas the complaint above name had filed a complaint case bearing number so and so against you, which is pending disposal of the court before the learned JMFC ANR Dibrugarh, my lord. My lord. The next page, my lord, 54, is the complaint petition, my lord. Now, your lordship may kindly turn to, my lord, page 57, the operative part, my lord. Page 57 below, my lord, paragraph 16, my lord. May I read, my lord? Page 57, my lord. Paragraph 16, my lord. Now that having no, last paragraph, that having left with no option, the complainant had lodged a written complaint before the OC Dibrugarh PS on 28/2/20, stating the entire facts of cheating, following which the said complaint was forwarded to the Duliajan PS, and accordingly a case bearing Duliajan PS case number so and so was registered. And next page, my lord, paragraph 17, that the said case was investigated by the ASI Bikram Ingti, who even did not recorded the statement of the witness of the said case, and in hurriedly closed the investigation and submitted final report. Next paragraph, my lord, that following which the learned court summoned the complainant on his appearance, and the complainant has filed his Naraji petition on 19/6/24 and a short date to file the formal complaint petition, and accordingly the instant complaint is filed, my lord. So this is the Naraji petition, protest petition, my lord. Now your lordship may have a kindly look at the, my lord, the BNSS, my lord. Yeah. BNSS. My lord, section 223, my lord, 223, my lord.
What is it? Regarding cognizance?
Yes, my lord. My lord, the proviso, my lord, provided, lordship got it, my lord, provided that no cognizance of an offense shall be taken of the magistrate without giving the accused an opportunity of being heard, my lord. In the instant case, my lord, no opportunity was given, my lord. No, actually, my lord, I am sorry, my lord, I could not annex that order, my lord. Can I give? Madam.
Okay. The complainant is absent by showing cause, white petition bearing number so and so. His absence is condoned based on the grounds shown. Witness, namely Sanjeev Mandal, is present for inquiry under section 225 of the BNSS. The said witness has examined as CW2 under section 225 of the BNSS, heard the learned counsel of the complainant, perused the case record.
No, just
Which-
a second. You have your impound order is of 8/12.
Yes, my lord.
You have to punish.
My lord,
It's a business. We are not.
well, upon receiving the summon, my lord, I approached this court, my lord. After receiving of the complaint, my lord.
No, but you have challenged the order of 8/12. Is it?
Yes, my lord, that's my lord.
You
My
have
lord,
to.
I may be allowed to file an additional affidavit, my
But
lord,
then
bringing on record, my
this is
lord,
the
the
record.
certified copy, my lord.
That is the order impugned.
Yes, yes, my lord.
Okay. State is a formal party.
The state is a formal party, my lord.
And this the matter when
Well, the next date is of my lord 2/6, my lord. Before that, any date, my lord?
2/6.
6, my lord. Can it be on my lord 28th of May?
20.
28. Yes, my lord. The 20, my lord. 20th of May.
Yes. This the matter according on 2008. And bring the petitioner side to file an additional affidavit bringing on record the order impugned.
I'm obvious.
May please, your lordship. Lordship, what happened in this case, lordship? The petitioner, Kishore Tati and one lordship, Poonam Tati, they were arrested, lordship, on a charge of lordship commission of offense under section 1031 of the BNS, lordship. And lordship, then lordship, they were granted default bail on 91st day due to lordship non-submission of charge sheet. That lordship, that default bail order lordship will find it page number 34. Page 34, lordship. That is order dated 11/12/2025. Lordship has got it.
Yes.
Page 34. Here, lordship may kindly see. No, lordship, this is not this is the cancelled order, lordship. What happened, lordship? That order, lordship will find at page number 25, lordship. Sorry, 25. Order dated 17/10/2025. Lordship has found it. Second paragraph, lordship. Progress report as called for is received from the IO stating that the instant case has been partly charge sheeted. I Dumdua PS case number so and so, dated so and so, under section so and so. Further, the IO has stated that the supplementary charge sheet will be submitted before this court after collection of the FSL report. Then, lordship, during the course of production, accused Poonam Tati, who is the second accused, lordship, co-accused, stated that she does not want to proceed with the private counsel due to financial hardship and further praised for legal aid assistance. Having considered the learned assistant LADC so and so is appointed to defend the accused in the present case. This is pertaining to the other accused who is not before your lordship. Inform all concerned accordingly. At the same time, seen a petition bearing number so and so filed by the learned assistant LADC and has prayed to allow the accused person, namely Poonam Tati, to go on bail on the grounds that the accused person has completed the statutory period in judicial custody and no final form has been filed by the IO till date. Then, lordship, moreover, also seen the petition file number so and so filed by the learned counsel appearing on behalf of the accused Kishore Tati. He is presently before your lordship, Kishore Tati, to go on bail on the ground that the accused person has completed the statutory period in judicial custody and further prays to release the accused person on bail by virtue of his indefeasible right guaranteed under section 187(3) of the BNSS. Then, lordship, both the accused persons were allowed to go on default bail. Why this order, lordship? Then, lordship, what happened? The complainant filed the petition before the court below, stating that there was suppression of fact. Therefore, complainant sought cancellation of this bail, lordship. And lordship, That order, Lordship, will find at page number 34. 11/12/2025, Lordship. Yes. There, Lordship, observation is that page 37, Lordship, then down below suppression and misrepresentation. Page 37 down below. It is admitted that on 17/10/2025, the Honorable Session Judge rejected the bail petition of both accused persons. This is the observation is wrong. Only the petition number accused number 2, Lordship, that co-accused, has filed a petition before the Court of Lordship, learned Session Judge, and that petition was rejected on the same date on which they were granted default bail. And that fact was not put to the notice of the Honorable Court below by the co-accused, not this present petitioner, Lordship. Therefore, Lordship, the learned court below has cancelled the default bail petition of both the accused person, Lordship. Whereas this observation is wrong, that the both accused persons were, Lordship, prayer of both the accused persons were not considered by the court, Session Judge, Lordship. Only the one co-accused, only the co-accused, Lordship. Then, Lordship, in view of this, Lordship, the Honorable Court below has cancelled the, Lordship, default bail of both the accused persons, including the present petitioner, Lordship. And thereafter, both the petitioners preferred a criminal petition before this Honorable Court, challenging that order of cancellation of bail. That order, Lordship, will find at page number 42. Lordship.
Yes.
42. Ishu Tati and that co-accused Poonam Tati, actually both are, Lordship, father and daughter, Lordship. The Lordship, they have challenged that, Lordship, order whereby their bail was cancelled. In that regard, Lordship, the Honorable High Court, order dated 18/12/2025, has been pleased to issue notice and also call for the scan copy PCR. And Lordship may kindly see para 10 of the order for page 44. Para 10, Lordship.
Yes.
Having gone through the order dated 17/10/2025 passed by the Court of Learned Additional Session Judge, FTC number 2 Tinsukia and bail application number so and so, Srimati Poonam Tati versus State of Assam, and the order dated 17/10/2025 passed by the Court of Additional Chief Judicial Magistrate Tinsukia, both passed in connection with Dumduma PS case number so and so. It is noticed that the petition number 1 did not prefer any application before bail before the Court of Additional Session Judge, FTC number 2 Tinsukia, and no order for bail on default was passed against him by the said court.
No.
That petitioner number 1 is before your Lordship. Issue 30.
Second, what you said, right?
Lordship.
Here in the criminal petition,
Lordship.
Poonam Tati was the number 2.
Poonam Tati was, Lordship, number 2.
And Kishore was number
Kishore
1.
is the present petition, number 1.
So what they observed, they did
Observation
not
is
prefer-
that
just a second, did not prefer any application for bail
before the
Court
session
of
court.
Additional Session Judge, FEC number 2.
Yes.
So this is Poonam.
Only Poonam Tati approach.
Huh?
Not Kishore Tati. Kishore Tati did not file any application before the Court of Lordship, Honorable Session Judge, Lordship.
No,
It is
no. It is noticed that the petition number 1 is your petition.
petition number 1.
Number 1 is your petitioner did not prefer any application for bail
Lordship.
before the Court of Learned Session Judge, Additional Session Judge,
Additional Session Judge.
and no order for bail on default bail was passed against him
By the said court.
by the additional session judge lordship. Because petition number 2 preferred a bail application before the honorable additional session judge, and that court has rejected the default bail prayer also with regard to Poonam Tati.
No, but your default bail was not allowed.
My default bail was before the court of honorable additional CGM lordship.
He allowed.
Lordship allowed.
Court allowed.
Allowed.
Ah.
Allowed. That is why lordship.
Oh, yes.
What I have seen,
Confusing.
what I have seen, the first phase lordship
Yes.
went to the CGM lordship,
Yes.
and in that case, on the same day, 17/10/2025, bail has been granted. And on the same day, lordship, it has been seen that a court has been there, part charge sheet has been
Yes.
given on 24/9/2025.
Mm.
On that ground, court has seen that as the default bail was for that person who does investigation does not complete investigation within that period. But since it is within that period, so court has
Granted
rejected,
default bail.
the default
For
bail
both the petitioner.
of both the petitioners. But what I have seen as per the record, lordship, then this petitioner Poonam lordship, Poonam Tati again went to the court for her bail. Then in that case, lordship, there, because it has already been rejected by the CGM lordship after on the 17/10.
No, not rejected by CGM.
It has been there.
Lordship,
It has
what?
been there.
No, it was granted by additional CGM most probably on default bail.
Okay.
And
Okay.
thereafter, as per you, she approached, Poonam Tati
No,
approached.
Poonam Tati actually approached 2 courts. First, she filed a bail application before the honorable additional session judge. Then, lordship, on the same day, on 17/10, her bail was rejected by the additional session judge. Her default bail prayer also, citing that part charge sheet was submitted. That order I have annexed, lordship.
So you were granted with the default bail.
Yes, lordship.
Then?
That lordship, what
What
happened?
is the purpose for again filing bail application?
That Poonam Tati, I have not done. That Poonam Tati has done. I only filed the application before the honorable court of additional CGM only. But since honorable additional learned additional CGM lordship has cancelled my bail also, lordship. Cancelled the default bail of both the accused person. That's why I approached before the honorable court, this high court of lordship. Criminal petition, lordship. Lordship, I can see this order, this observation is very clear, lordship. At page 10, para 10. Because I did not prefer any application before the court of session, lordship. But Poonam Tati has approached applications before both court.
Why? Why she approved?
But that is her because I'm not appearing for her, lordship.
To default bail, you were.
No, on the same day. Because on 17/10, learned court of additional sessions also rejected my prayer of Poonam Tati, lordship. On the same day, learned additional CGM also granted bail. That is why on that suppression, the learned additional CGM lordship has cancelled the bail of both the accused person. Because it was of the view that that rejection by the court of additional session judge was not brought to notice of the court of additional CGM lordship. That is the lordship observation of the court below. But so far, this petitioner is concerned, he has only filed application before only one court, that is the additional CGM court.
What I have seen, lordship, in the CGM court has granted bail on 17/10 to both the person.
Yes.
Then in the same day,
Same
17/10,
day.
2025, from the records I am telling, lordship, in the court of additional session judge, this person petitioner 2, that is the
Poonam Tati.
Poonam Tati. She again, I don't know, lordship, she again went
That-
to that court.
That application was pending prior to that lordship. That
In
it
that
was pending.
case- In that case, it has been rejected. And the ground of rejection is that
Part charge sheet.
part charge sheet is given. And in regarding to that, within that period, lordship, the charge sheet has been filed.
Part charge sheet only.
Part charge sheet has been filed. And it has also been, a case law has also been decided on Kapil Wadwan lordship. In that case, it has been stated that, though in Ritu Sabaria case lordship, it has been stated that this type of part charge sheet cannot be given. But in subsequently, lordship, in Shibe versus Kapil Wadwan lordship, it has been stated that it can be given if sufficient materials are there. And in this case, sufficient materials has been there. only the supplementary only remains of FSL lot. FSL and so it is. So it is considered as a material charge in regard to this Kapil 1-1 Supreme Court case law, Honorable Court law decision. So it has been rejected. And again, I have seen that lordship in NA on 11/12/2025. Again, I will
Cancel. Cancel, please.
it has been everything has been looked out. Everything has been looked out by the Honorable Court Lordship Court below, and taken the position that this case in this application Lordship 17/10/2025, it has not been stated that it has been rejected earlier, because it has been rejected on 17
On same day. On same day.
it has been rejected, and it has not been stated before this Honorable Court.
Edition system.
Edition system. And on that ground, the case law has also been cited. It has been stated that regarding that if the this one lordship default bail also given, if something has been given the suppression of the fact, the bail can be rejected. On that ground, it has been rejected. So there is no illegality, lordship. Lordship may kindly look into. And now the thing is that lordship, whether it everything is there, lordship, I have tagged now the question remains whether within the stipulated period, charge sheet has been submitted or not. That is the request.
No, that is not the question. Because
it is cancelled on that ground also. On that ground, lordship, that they have got default bail because the charge sheet has not been submitted.
Oh, now Mr. Hassan's case is different. He is saying that that application before the additional session judge was not filed by him.
What?
He was given default bail by the additional session CGM, but before additional session judge, he did not file any application.
lordship.
But while considering the case of Poonam, the other case is also
Cancel.
cancelled. Bail was also cancelled. That is his case. Now the question is that after that rejection, you have already filed a criminal petition.
Criminal prison. That
So what is the order?
that order.
Observation you have already submitted before
Yes.
in that in para
Yes.
10.
Yeah, para 10.
Then
lordship may say para 11 10. Here lordship the problem arises lordship. Para 11 lordship may para page 44. As it is prima facie discernible that a petitioner number 1 filed a bail application only before the court of additional CGM Tinsukia and did not file any application for bail before the court of additional session judge. Tinsukia, that part of the impugn order dated so and so, by which the court of additional CGM Tinsukia has cancelled the bail of the petitioner number 2 shall remain suspended till the returnable date. So although this honorable court was intending to stay that part of the operation of the order with regard to petition number 1, however, inadvertently it is reflected as petition number 2. Lordship, may kindly see last line. The petition number 2 is the Poonam Tati lordship. So this honorable court was
additional chief judicial magistrate did not cancel.
additional CGM cancel.
That part of the impugn order dated so and so by which the additional chief judicial magistrate Tinsukia has cancelled the bail.
Yes.
Where Tinsukia has not cancelled.
Additional
It is the
CGM.
additional session judge had cancelled.
No. Default bail of both the accused was cancelled by additional CGM.
Subsequently.
Not subsequently. That order I have already.
After rejection of the order by the additional session judge.
After rejection. When the complainant filed the petition.
Once it was granted and default bail is rejected for both of you.
For both. For both.
It's considered.
It's my limited knowledge, lordship, what I want to state here, lordship. Since 1710, the default bail was granted to both of them.
Yes.
Then how can lordship, only one can be on same ground, default bail, one can be rejected and one can be accepted, lordship. That is why both are rejected. I want my limited knowledge, lordship.
No, but his submission is that only suppression of fact, basically that was there. But there are other observation also.
Other observation.
Observation is there, and then accordingly it was rejected.
Lordship.
So now, what is in the criminal petition is fact Tinsukia has cancelled
Lordship,
and
that,
remains suspended.
that,
So now let's take case on 4-2.
Lordship. Then lordship, what happened? Actually, while this honorable
And 4-2, what had happened?
4-2 lordship, that interim order was continued, TCA was not there, and notice was also not served.
In spite of pending that criminal petition, now you are approaching this court with a
No.
bill application.
No, because I have approached the court below. Court below has rejected my bail.
This thing before because it is an observation that you have not approached so and so, these are the things. So that's why don't you procure the order and place before the court where the criminal petition is still lying?
That I have lordship placed. But despite that fact, I have been remanded to custody.
Remanded to custody is okay. Why? I'm saying that 4/2/2026, the matter was fixed.
Fixed.
So what had happened on that day?
On that day, this interim order was continued. And the scan TCR was not available. And notice, lordship,
What was the interim order?
this order, that part of the impugn order that stayed with regard to petition number 2.
What will be the order that is ordered? Means
That
what?
Petition number, actually inadvertently it was
No, what? 1 or 2, whatever. What is the order? What part remains state?
that the impugn order cancelling the bail is with respect to petitioner. Two
No,
accused,
that
2 accused.
state.
That part,
you are on bail.
that part was stayed only with respect to petition number 2.
No, whatever. 1 or 2, let's forget about it.
Yes.
That part, what had happened then?
That was continued, lordship. That order was this order.
You are on bail then.
No, I'm not on bail because that is why, lordship,
What? Your bail has already been rejected.
after this order, my bail was rejected.
After which order?
After this Honorable High Court order. This criminal petition order.
How?
That lordship may kindly see
No.
for a moment that case is committed to the Honorable Court of Session, lordship, after filing of final charge sheet. But lordship may kindly see.
You then phrase it is already charged sheeted.
Charge sheeted.
Case has already been committed.
I filed.
So why don't you appear before the session judge now?
Session judge is rejected. Lordship may kindly see. That is why. Page number 83.
So in spite of now, what is your prayer in criminal petition now? It's gone.
No, it is there.
No, what was the prayer in criminal petition then?
To set aside that cancellation order.
Then now?
That is now pending consideration. Criminal petition is the pending.
Cancellation is also there. And then again you have opposed these. No, there. How?
No, because I have been taken to custody, lordship.
Oh, you are in custody now. Why don't you approach the learned trial court below now or the learned session judge?
I have approached after this order.
So you have forget about this criminal petition. Gone.
I will not forget, lordship.
Already gone.
Not gone, lordship. Lordship may kindly see. That's why, because I have been taken to custody.
Oh, you are taken into custody.
Then I cannot wait for the criminal petition to dispose, lordship, finally. For that, I have approached the learned court below after charge sheet of the committal of the case, lordship. But court below has rejected my prayer.
Court below had rejected you.
Rejected. That's why I am
before committal court or where you have appeared?
Before committal court also and before the learned trial court also. Session
Where
court
is
also.
committal order?
Committal order, lordship, may kindly see page number 71. Page number 70. Page 70.
It starts from. It starts from
page, lordship 65.
Yeah, it starts from 65.
65.
So this is the detail order which has been passed.
Yes. Starts from page 6.
It is the additional CGM. Where is the committal court order?
Yes, additional CGM. This is page 65.
What is the order of committal court?
Rejected my prayer, remanded to custody, and fixed and committed the case to the court of session, lordship.
And then court of session, have you preferred any?
Yes.
That is, where is the order?
Page number, lordship 8.
Page number 8.
75. Order dated 4/4. 4/4, lordship. Session case was registered, lordship. Then, lordship, 76. It starts from 76. Lordship, may kindly see para 11. Page 82. That is what I was trying to submit, lordship, that inadvertently it was petition number 2 mentioned.
Whatever gone is gone. Your petition, your default bail has already been rejected.
Default bail has gone. But now that since the case is charge sheeted.
Now you come to the merit only because now default bail chapter is already gone. So 2-3 orders has already been passed regarding the default bail, whether you have approached or not. But because both the petitioners were on same footing, so it was considered together, maybe inadvertently or whatever, but it was considered together. Your default bail petition was accordingly rejected, or prayer was rejected. And
But-
after
but-
this order of
Lordship,
criminal petition, your
Default
enter
bail,
bail and you are committed or demanded through
default bail as of now, Lordship, stays because of the order passed by the passed by the Honorable High Court in the criminal petition order.
Then your matter will be accordingly before the maybe tagged with this one criminal petition. We will not be able to.
And on merit
Cannot
also,
pass separate this kind of order now.
on merit also, Lordship, I undergo Lordship for 91 days. Thereafter, Lordship, now 39 days since the day of remand.
Confusing report, like. Your this additional session judge who rejected your order subsequently, it was discussed on simply on merit on the or on the default.
Not merit. It was because the observation was that since the matter is pending before the Honorable High Court, criminal petition is there, Lordship.
Then in
That-
the criminal
that part.
petition, so why you confusing?
No, not on.
Approach the criminal petition, try to dispose of the criminal petition in your favor or whatever. You are again submitting, confusing the court. By two order, we cannot. One order, the stay has been passed. You are not challenging that order. You want to take the advantage of that stay. And now you are again approaching this court with another petition. So it will be really confusing otherwise.
Because Lordship, since the already I undergone Lordship 91 days, now 39 days after remand. Lordship, whether it is a committed also, Lordship.
If you have simply on the case on merit, then otherwise, but on the law points, then it is already been subjudice before this court in criminal petition. So difficult on our part. Same bench, same coordinate bench order, it will be difficult. There may be observation, maybe otherwise also. It will again create another problem. So we are not going to supposed to pass any order here.
On merit, Lordship, that already is all charge sheeted.
For submit on merit, or if the entire petition is been on merit, then it's okay. Otherwise, because your entire petition now consisted on not only on merit, but those the legal ground also is there. So that will create another problem. That's why I'm saying, Mr. Hassan. Otherwise, you withdraw this, simply file on merit. We may consider no issue at all. But if you insist on that particular aspect, then again it will create a problem because criminal petition is still there, and you are not going to take the advantage of that stay order. Still you are going to take the benefit or whatever favor. What was you are supposed to say that it was in your favor because stay was there, that operative part. So in that case, it will again create problem. So what I'm suggesting, Mr. Hassan, either you withdraw this one, file a fresh, but only on merit. Let's forget about all these other things. That case we can see it. Otherwise, so create problem.
Merit also, Lordship, since Lordship it is fixed for Lordship CC, consideration charge. Then Lordship, whether custodial detention of this petitioner is required.
No, what I'm saying, your entire petition is not only on merit, but there are materials. That's what I'm just simply saying. When it is fixed on your cards.
It is fixed for today appearance. Today it is fixed for appearance.
Appearance.
Next, it will be for
You have
CC, Lordship.
you are still in the jail, most probably it can be no issue for your child or whatever. So, think of it. Otherwise, we have to pass order may not be so favorable for you because there are other issues relating. That's why same issue cannot be 2-3 times. It cannot be decided on that part. One criminal petition is just where that part is already stayed. It will be difficult on our part also. Do one thing, Mr. Hassan. You just simply withdraw this one. The other will call for this BA along with this petition. These things are already here. I mean, what I mean. TCR is already here, so it may not be relevant to call for again for the TCR because if we tag with this BA along with that TCR, it will come together. So you just
that can be tagged.
That can be taken.
Yes, later.
But also simply, if you withdraw this one, it just simply merit. Tomorrow itself, you can file a petition. It may come by day after tomorrow or whatever. If it comes, then we may fix take this BA along with that fresh.
Fresh.
I think that will be sufficient because this will otherwise create complicated. And I'm saying, simply I'm saying, rather, because may not be favorable for you also. I don't know. Because there are issues are there.
Issues.
So we have to, those issues are also there. That apart, criminal petition is still pending.
That is pending. It will
Still
take some time. It's pending.
Time, but still pending. Still. And by that time, why don't you do one thing also? Because criminal petition is pending. That part was stayed. You have said that operative part. But in spite of that, on the basis of that, you have taken into remand or custody. So that aspect also can be brought before the in the criminal petition. I think so. That may also because stay or the operative part was there in the order. May help also you, I think. Let's think about it.
Yes.
Yes, and then you come before this court because otherwise the whole issue is very complicated.
Yes,
now.
yes.
Now see, the question is that on the same footing, because what had happened when we are trial judge, suppose one petition, no petition is moved or bill petition was there, because if the petition is entitled to default bill, then they automatically order of default bill also can be passed so moto by the court. No issue at all. So taking into consideration, suppose 2-3 petitions are there on the same day, the default bill can be considered, so it can be considered. So similarly, in that aspect, most probably maybe advertently or inadvertently, the learned additional CGM had passed the order for the cancellation of bill. That may be there because of the same footing. You are in same footing because both the petitioner, daughter, brother, or whatever, but you are in same footing. 103 matter.
Yes.
So that's how it was cancelled. Pardon?
Different or the default or
Bail order. Same
the same order. That is why if one cannot be rejected, Lord. If one has to be given bail, then other does not give, then it will be violation of equality, Lord.
Yes, that will be again a violation.
But the suppression part is not regard to me.
With you.
That may be different. Because it is tagged with order is same, Lord.
Same.
Because default order is the same.
And that apart, you have already pointed out that this is 1 or 2. There's already one confusion in the criminal petition itself.
Yes, Lord.
Because 1 and 2 is
1
also
and 2,
there.
1 and 2.
That,
For that, we have filed one IA also for correction.
You have already filed.
That is not, Lordship, you're not yet listed, Lordship.
Not yet listed.
Yes.
Already you have filed.
Already filed, Lordship.
Mr. Hassan, I suggest that you just withdraw this one and immediately by tomorrow or by the day after tomorrow, you can file simply on merit. Then it will be possible for us also to consider, I think. Or you can think over it. I will list it another day otherwise.
Lordship.
You think it. We're not in a hurry. Think it, and then if you think that we can list, then we are listing it on He's saying 14th will do.
14 will, Lordship. 14 will do.
So I was simply listing it on 14th.
Yes.
Okay. Kutu was 34. Heard Mr. N. Hassan, the learned counsel for the petition. Also heard Mr. K.K. Das. The learned additional PP appearing on the state response. List the matter. Yes, can copy of the TC. Hello. List the matter. 40. We're simply listing it on 14. Think
14.
of it, Hassan, and then
Obliged.
May it please, the regular bail application, Milord. I'm
yes, what is
67.
the position of 35? Series. Okay.
I'm 67 days behind the bar. Lordship will kindly come to page number 9. That's the FIR. Lordship has found. Page number 9, madam. May I read?
Yes.
I respectfully submit that about 6 years ago from today, my elder sister so-and-so aged so-and-so was married socially to the accused number 1 mentioned below. After the marriage, under the ill influence and instigation of accused number 1, she was continuously subjected to various forms of physical and mental torture, harassment, and assault. And during such torture, my sister continued her matrimonial life with accused number 1, during which 2 children, a son and a daughter, were born. For the sake of these children, my sister continued to tolerate the cruelty of the accused, and on several occasions, village mediation settlements were also held. Subsequently, accused number 1, under the instigation of the other accused persons, expressed his intention to marry another woman, and when my sister objected to this, the accused, out of anger, on 23/2/2020, it will be 23/2/2026, my lord, there's a drafting error. 23/2/2026, at about
1 a.m. in a pre-planned manner, assaulted my sister and murdered her, thereafter hanging her body inside the house. Later on today at 11 a.m., when I came from my house, I found that my sister had been hung inside the house and the accused had absconded from the place. I mean, primarily, we are objecting the date and time of the offense. We have also, on earlier occasion, we also said. Now, the actually, my lord, what happened, the sequence is like this. I am a my lord, local shop owner. I have a ration shop nearby my house. And on 24 to
You are accused
2026,
number one.
I am accused number 1, my lord. I am the husband. Only I was arrested. None of the other accused have been arrested. So on 24 to 2026, my lord, when I went to my shop, at that point of time, she was well, she was, I mean, healthy, happy, everything. Now, when I went to my shop at around 9 a.m., thereafter I got a phone call from my house that this incident has happened. So when they have alleged that it was on 23 to 2026 at around 1 a.m., just to ensure that, as in general, I will be at the home, my husband will be at home. So just to plan that. Other than that, Milord, the entire offense was between somewhere between 9 to 11 because
As per you, you have received
Yes.
a phone call at 9 a.m.
not at 9 a.m. Milord, I went from my house. At that time, she was alive. On 24th. Thereafter, Milord, I got a phone call. I came back. That's why, as per my instructions, Milord. Anyways, Milord, and Milord, the FIR was lost after 3 days. The FIR was lost on 27 to 2026. After 3 days, the FIR was lost. And Lordship may kindly come to page number 22. On the very same day, I was arrested, Milord, within a span of 4 hours. I myself surrendered before the police, and thereafter they arrested me. Now, they did not, page number 22 is the rejected bail order, Milord. Now, the bottom 6th line, now they did not request it for my police custody. Simply, I was remanded to judicial custody. And this, Milord, kindly say this truly signals that at that point of time, Milord, a preliminary investigation was completed. That's why I was not remanded to the police custody. And thereafter, Milord, 67 days in custody. And it can be presumed that, Milord, looking into the nature of this case, Milord, it is not that much complex. So looking into the nature of this case, Milord, 67 days in custody. So looking into the length, of course, there's a lordship's prerogative. I cannot comment on that. So 67 days. And Milord, with regards to the flight risk, Milord, I myself went to the police to surrender before the police. So with regards to the flight risk, because 27 to 2026 at around 9, the FIR was lodged. At around 1:30 a.m., I was arrested. I myself went to the police station. So with regards to the flight risk, my presence can be secured at any point of time. And Milord, I have two minor children, Milord. Their right to life is directly associated with my liberty. So at least looking into all these conditions, Milord, my liberty may be granted to me, Milord.
Yes.
Madam, here we have received the case, madam. We have PM report also here, madam, but it is not complete, madam. The PM report, madam, opinion regarding cause of death is pending till that of the case analysis report of Sutera are received. Kept pending for their SSM report not yet received. And madam, from the PM report, some injuries are found, madam, here. Like madam.
Tell us about the injuries.
And they give some kind of from the witnesses is evident that there is a physical and mental torture in the Koda Mala incident Mala.
provisional PM report is also, this is the provision. I mean, cause of date is not there.
Special report is different. Just in the opinion part. Pending, keep pending.
The statement of some of the witnesses are there regarding torture, but some the neighbors most
In the
of
letter.
that they,
That's came.
they
Yeah. This is. This is hard.
that about this the injury. That's why I'm just perusing the report. The injury which is sustained basically on the
Some of
cheeks area
them
and some.
Old also one of the.
One old one was the cheek area and all. This cannot be the reason for death. So obviously there was a ligature mark
Mark.
that was depressed also so and so. Maybe a picture of suicidal hanging, maybe a picture as I said, maybe 301 or 103 also. Cannot see at this stage. Yes, otherwise what to say is 67 days in custody. PM report obviously it is awaited.
But final opinion. Final not very accessible. There are
Yes. You are SS
SS Ahmed, my lord.
Mr. SS Ahmed with an account petition and also heard Mr. B. Sharma Leland PP appearing on behalf of state respondent. It's an application section so and city receipt submitted by Mr. Ahmed on counsel for a petition that he has not committed any such offense as well as the rather on the day of he went from his house at about 9 a.m. Thereafter, he heard about the incident. They rushed to the place of occurrence and saw the deceased dying in a hanging. He submitted that on the day itself, he surrendered before the IO, and since 67 days, he is in custody. As he surrendered before the investigating officer, there cannot be any reason for, there is no flight risk for the present petition. Rather, he will extend his cooperation in further investigation of this case as and when his cooperation. Mr. Ahmed further submitted that on the day of his arrest was produced for the court, and accordingly he was sent for judicial custody, and the IO did not pay for any police remand or police custody for his custody intervention. As the accused petitioner is in custody since the 70s, Gauhati Ayo got good opportunity to interrogate him during him in custody. However, the petitioner did not give him custody. Accordingly, he prayed that privilege of bail may be granted to the present petition. Mr. Sharma Dilane submitted his that PM report is provisional PM report is received, but the final opinion could not be given as a report from aforesaid is still. However, he submitted that from the materials available in the case diary, it is seen that there are sufficient incriminating materials against the present petition, and some of the witnesses also stated that he used to torture the victim mentally, physically before her. Mr. Sharma accordingly submitted that further custodial intervention may be necessary for the purpose of investigation. Next, hearing this submission made by the proposals, considering the matters left in the case diary, and also considering the length of detention already undergone by the accused petition. This court is of opinion that further custodial intervention may not be necessary for the interest of the investigation. Accordingly, and it is to extend the privilege of bail. It is the case of which place Koprajan
Present case, my lord.
CGM to the satisfaction of CGM.
Okay. I'm grateful, my lord. Okay.
Well, I would get her. Okay. Okay, to put that.
Okay.
Here 38 and 39 36 17.
Are you on interim there?
No, interim was not.
You are not on interim. Then you have to approach the learned trial court below, huh?
I think TCN will be called me.
No, cannot call.
Not
It
yet.
is AB and that too you are not on interim.
My lord.
You are Mr. R. Amin.
Yes, my lord.
Actually, he was Mr. R. Amin, the learned for the petition. So had Mr. B. Sharma, the learned additional PP appearing on behalf of state. So it is submitted by Mr. Sharma. That case has already been charged sheeted. Right CS number, yes.
My lord, had charge number 5 of 26, dated 28/4. 26. 5 of
So as you are not on interim, we are not passing any other order. You are just simply asked to appear before the learned trial court below with an appropriate application for it. In case
Right.
any rejection, you can approach valuable approach court.
Developers.
May I please say lordship, yes. Yes.
Yes, what is 42?
FIR is on.
Justice.
My lord, CD not received, my lord.
CD not received.
My lord.
You are not on interim, I think, na?
No, lordship.
Case relates to which section?
103, 118, 117, lordship.
1032, we don't have any alternative. CD
Right.
has to be there. Okay, then why CD is not there? Is there any?
My lord, here CD and PM report was called from.
No, CD and PM report. No,
Right.
why it is not in any
My lord, not any information.
URMs?
It came so yeah, lordship.
MSK M. Sekya, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned additional PP appearing on Gauhati state response. It is submitted by Mr. Sharma that CD not received, which CD along with the medical PM report is
Right.
not received. However, he submitted no intimation is received from the I. In view of this, later reminder be issued directing the IO to furnish the CD along with the PM report on or before the next date of this. Yes, when it can be listed.
My lord, 21 number, 21.
21st of this month. Let's see, we may reach, we may get this. Lords. Yes, what is the position of 43?
My lord, still see.
Herein, your lordship, a 20 years old boy, your lordship, if you
Do.
case 12 is the affair, your lordship, kindly have.
Uh-huh.
Case 12 is the affair.
Yes, very. এর বন্ধ করবে, বন্ধ করবে।
Is it said everything now?
Yes, what is it?
Case 12, your lordship, I am reading
Yes.
the affair.
Yes.
It is respectfully stated that as per conspiracy of the above named accused number 2 and 3, the accused number 1 has been making obscene gesture to me for last couple of months. And the accused number 1 uses to visit our house without having any reason. Most of the time, my husband uses to stay out of the estate for livelihood. On 17 to 2026 at night about 9:30 p.m., the accused number 1 illegally trespassed into my house as per instigation of accused number 2 and 3 by taking advantage of absence of my husband in home and committed rape against me, my will. After the said incident, the accused number 1 again made a proposal to have sexual relation with him. On being refused, the accused made various threatening to viral my absence photo on social media. Herein, the accused number 2 and 3, they are the father and mother of the present petitioner, your lordship. And the Ellis incident was taken place on 17 to 2026, but the affair on 14/3/2020,
17 to
17 to 2026, but the affair was lost on 14/3/2026. In fact, your lordship, the informant, she is a married lady who is the relative of the petitioner. I have stated in para 6 of my petition, because the sister of the present petitioner got married with one Rafiqul Islam, who is the brother of the husband of the informant, your lordship. In para 6 of my petition, I have made a statement. And here in the petitioner, he has a brilliant academic career, your lordship, in PACE and in Annexer 1 and 3, your lordship, kindly have a look. In 3, in recently he has already appeared in the JEE exam 2026, your lordship, to get admit in BTech or B course, your lordship.
Hmm.
In
And
20
what
years
is his
old,
result?
PACE
What
3,
is his result?
PACE 10 and 11, your lordship, kindly have a look.
Oh, these are things. No, what NIT result is?
He has already appeared in the JEE exam.
Okay, yes, JEE, then
JEE exam, your lordship,
he
2026.
got selected?
I think the date of examination was 2/4/2026. The result, I think,
Not yet.
yet not.
I have seen this once 183 statement. If you go by the contents of the FIR, it are contradictory statement. In FIR, he stated that forcefully he had physical relationship with her. Then again, with the instigation of 2 and 3, he again want to have physical relation. A proposal was given and then setting was given and thereafter the FIR was closed. But here, something different story is there. Were made by she was unconscious, photograph was there, lying was there, again came, these things are there. Therefore, if you go by the contents of the FIR also, it seems that under the instigation of 2 and 3, it seems
They're the
quite
father.
absurd that your mother and father
Yes.
will insist a boy of that to 20, 21 years have this kind of relationship with a married woman who obviously have has children and all. It seems absurd. I don't know. Maybe reason may be there, may not be there.
Something is there, but
Something. She may be interested. You cannot say. Pardon, Mr. A.M. Khan, the learned-
medical,
Pardon?
medical.
Oh, here, no? Sorry.
medical.
Medical report. What is it? Huh? Even if suppose she undergoes for any medical report also, medical examination, it not help so much because she's a married woman.
Married woman.
So with and that apart after 4-5 days or after some days it is gone through also. And as per FIR, it is the FIR was lost after about 1 month. So medical will not.
Have different
Yes, yes, sure.
quantity. Yes.
Yes, yes. Mr. A.M. Khan, Mr. Isha, the additional PPA an application. Submitted by Mr. Give some further further submit the contents of the FI is absurd because one cannot commit such kind of offense on instigation of his own parents. Further, he submitted the occurrence took place on 17/2/2026 and keeping silent, she lost the FIR only on 14/3/2026. She is a married woman and wanted to destroy the life of the presentation, who is a boy of 21 years. The FIR has been instituted. However, he is ready, willing to extend his cooperation in further investigation of this case if he is granted with privilege of pre-arrest. Next part. Mr. Sharma, the learned will be submitted in this that there are sufficient incriminating materials against the petitioner in the statement made by the victim under section 183 BNSS. He submitted that considering the case diary, it may not be a fit case to extend the privilege of pre-arrest bail to the present. Hearing this submission by also consider the materials available in the case diary. And after perusal of the case decide, it's seen that it is a that the petitioner is entitled for privilege of pre-arrestment. There will be some conditions, abide by all conditions appear before the IO and make your statement recorded before the IO. Last word.
Yeah, please, Your Lordship.
Oh, no.
My lord, maybe taken up day after tomorrow.
45. Why?
45, my lord.
Why?
My senior has left the court due to some unavoidable circumstances, my lord.
For your convenience, we cannot take, na? For your convenience, how can we take? Yes, when it can be. Otherwise, one scan copy of the
Yes, my lord.
share
That is
along with AB
yes,
is
my lord.
received.
My lord. That is received, my lord. That is checked, my lord. Already checked.
Okay, 7th of 7th.
7.
The request made by planning council for petition matter will be dismissed. The other matters will be adjourned wherein there is any, deferred. If any interim is there, that will be considered, we'll fix it. Otherwise, rest all will be deferred. Oh, issue.
Highly aware.
Yes.
May I
May-
say date item 31, my lord? May I say next week or 7
No,
or 9?
no date will be found, all will be deferred, except the interim where interim is there. Except.
My lord, may I
Others-
pray regarding item number 46, my
If
lord?
interim is there, then definitely.
My lord, it has to be closed, my lord. It's
No.
a appeal, my lord. So, my lord,
Huh?
it has to be closed because, my lord, the appellant has already been released from the jail long back in the month of June 2025, my lord.
We'll
And
see to it. Not
my
in a
lord, so,
position
my lord,
to hear anything.